I'm going to give that just a moment for it to get started. This will be creating the YouTube link that people can watch on the ASUCI YouTube. So if you're a streamer, let them know that you have a stream going right now. Alina, what a gift to be able to see you. I haven't seen you in forever.
Yeah, I have to turn off my virtual background because I had to have it for a class. Give me 1 second, and then you'll see me again.
Okay, I just checked. Our YouTube link is a go. I'm gonna be setting myself. You may all do as you wish. I'm gonna be setting my video camera preferences to hide non-video participants. That way, I can only see those that do have a camera on. Okay, great. So thank you everybody for coming to the formal hearing. I know this has been a long process for many of you, and I really greatly appreciate you all being present and coming along with us during this wild ride. So to start a few things off, your how we'll be presenting our time. Let me get my paper quick and ready. Unless someone else has it right in front of them and can tell them the time faster than I can. Found it. Okay, wonderful. So we will be starting with each side. We'll have 10 minutes for opening statements. We will then be moving on to the prosecution. We'll have 1 hour to present any evidence, witnesses, and so forth. The defense will be given 20 minutes to use in that hour to cross-examine. So whenever the defense cross-examines the prosecution's 1 hour time will be paused and we'll be going into the defense 20-minute time. So this hour could essentially be an hour and 20, depending how it is used. We will then be having a 30-minute break after the prosecution presents all their evidence. We'll have a 30-minute break. Then we'll move into 1 hour of the defense presenting all of its evidence and all of its witnesses. The prosecution will then be given 20 minutes to cross-examine if they so wish. From there, we will be opening up to the board, having 30 minutes of questioning for either side. After the 30 minutes of questioning, you both will each have 10 minutes to rebuttal, and then we will move into the final moments, which will be a 10-minute closing statement. Does anyone have any questions about how our schedule will be looking? Wonderful. We will be having our clerks chime in if you do hit time. We are reserving all of our time to our clerks. We have prepared them and told them how it will be looking. So we are extending this power to our clerks so that they can be able to tell you your time. If you ever have a time question at all, please feel free to chime up. I know we're not in person, so things are a little bit weirder now than they would be in general. So do not be afraid to chime in, ask a question, or anything of that sort. Another few ground rules before we go in. Obviously, those who were at the preliminary hearing know this, but I'll be stating it again for the public. The judicial board is not bound by Robert's Rules of Orders, as it states in the Constitution and the bylaws. So if there's a point of contention, we will be using our own thought process through it all. We will not be referring to Robert's Rules of Order for it. My apologies if you have any issues with that, but we made sure to have clearance that this is something we can do. It is something that everybody has told us we can do. But if you have any points of contention with that, please feel free to voice it. And you can also email us after or anything of that sort. Yes, we will not be creating a verdict tonight or today. That verdict will come shortly within the week. We will be deliberating tomorrow, and you can probably expect our opinion by Tuesday at the latest. So that is the time frame that we're giving ourselves in order to release an opinion piece. Does anyone have any questions before we proceed forward?
I don't know if this is appropriate, but is it possible for me to request when you release your hearing, your whatever?
Yes, we will be emailing you all out a copy of it as well, so that
No,
it's just.
that's not my concern. My concern is when the elections if they are removed, all Senate legislations are hereby injuncted upon based on the Constitution. There's two referendums coming to us Tuesday and Thursday. So if you release the thing on the Monday, these things are basically just gone.
We will keep that in mind. Thank you.
Sorry, that's a big thing for the referendum.
Understood. We will keep that in mind when going forward and choosing our verdict. Mr. Gandol, do you have anything to say about the defense or anything before we proceed forward?
A quick note of clarification. In the preliminary, you said Roberts was the lowest tier of reference. is now Roberts not a tier at all of reference?
Excuse me, I definitely misspoke now. It is still the lowest tier. It can definitely still be used, but it is at our lowest tier. Thank you for your clarification, Mr. Gandalf. Appreciate it. Let's see. Okay. Do any of my justices have anything to like to tune in? Did I forget anything? No? Wonderful. All right. Then we shall be beginning with this hearing. May we please have the prosecution start their 10-minute opening statement. You will be timed on your first word, and our clerks will be timing for you.
10-minute opening statement? Oh,
yes.
Okay. Sorry. The thing you sent me said 2 minutes. Anyways, I can make it 10.
I'm so sorry, Mr. I'm so sorry, Ivan.
It's fine. I'll just go into my main argument then. All right. Hello, everyone. My name is Ivan Fonseca. I am the current ASUCI Senate President. I am here to argue that the ASUCI Election Commission should in fact be removed from office after being impeached by the ASUCI Senate in R5663. Winter 2021 impeachment of the Elections Commissioner and Deputy Elections Commissioners. We, the ASUCI Senate, have the sole right to impeach officers of the ASUCI government. Specifically, for elections, it's Article 10, Section 4, Subsection A. The Senate may impeach the Elections Commissioner by 3/4 vote. Subsection B, the Senate may impeach Deputy Elections Commission by 2/3 vote. The Judicial Board must then hold hearings and determine whether the official should be removed from office, and if so, whether they should be barred from holding office in ASUCI for a period of time. That is what's stated in our Constitution. Historically, the way Judicial Board has decided to rule on impeachment is basically following the safety test, which I believe it's the most standard way of actually doing it. And then the safety test is basically this. The safety test is required a showing of 3 elements by the plaintiff. First, that the Senate must have adhered to the governing documents. The only government document that mentions impeachment in the Constitution is the Constitution. And that simply spells out the voting threshold. So that condition was met. We follow the governing documents. We have the voting threshold. Charges must be grounded in the Constitution. The Constitution clearly states, Article 5, Section 1, Subsection B, that the members of the Election Commission must not have made a financial donation to the ASUCI candidate for elected office within the preceding year. Whereas Ryan Pavey reported contributions of $165.52 in his 2020 spring general election financial statement. It is very clear that is an argument based on the Constitution, and he is in violation of it. The second charge, the Elections Commission must call a special election within 3 days. The Elections Commission did not call a special election with 3 days. They failed to do so, and that is an argument based on the Constitution, following the safety principle. And finally, third, the Senate must have acted reasonably. Considering we acted to fix something that should have never have happened, the appointment of the Elections Commissioner, and sheer fact that the Elections Commission failed to respect the direct democracy and failed to protect democracy itself when it was their constitutional obligation to call a special election within 3 days, we do believe we are acting reasonably. The legislation impeaching the Elections Commissioners and the deputies, it was posted on the Monday and was voted on Thursday. That was for 3 or 4 days. The Elections Commission could have came to Senate. They could have emailed people and explained themselves, or go forth and ask questions of why we were doing this. They did not say anything at all. They never emailed, they never showed up, and that was it. So we did act reasonable. We followed the proper procedures, and we did everything we are supposed to validate these petitions, the removal of these people. I have provided my stance. In the past, the defendant has excused the Senate's impeachment of the Election Commission as serving as an act of political vengeance, as well as alleging the Senate denied the Election Commission their right of due process. Neither claim actually makes sense if you think about it, and I'll be making the case for this today. First of all, when it comes to acting political vengeance, I haven't actually heard an example of political vengeance, to be honest. Last time during the pre-hearing, all I heard was, well, the people who were impeached were part of this group, and the other people who were not part of this group were associated with this group. That's basically what I have heard. And that's not what this is about. We could care less about that group or what the people did in that group. What we did care about, and the reason we are impeaching them, is, as it was stated, they violated the Constitution for not failing to call a special election, for failing to call a special election within 3 days. That is just a fact. There's evidence. I sent you the screenshots. I had Aaron, our neutral ASUCI person, tech guy, to validate that yes, those are in fact official records that this person did in fact donate that much money to his campaign. That is a fact. You can't deny it. You really can't. Last time we were here, the defense denied it. Which, sorry, but that denying that evidence, denying when it was certified by several people, is basically the equivalent of denying the concept of reality itself.
Your Honor.
Yes, Mr. Gandalf.
The defense would object to this because it was made explicit that administrative evidence can't be submitted for testimony, so can't actually be cross-applied to any cross-examination. So we'd ask the court discount any allegations of administrative communication, considering by definition of what the court has set, they cannot be considered.
Ivan, you provided us multiple screenshots in your evidence. Were all these provided by Aaron, or were some of them gone by yourself as well?
The screenshots, all I asked Aaron to do was to basically revert the elections website back to what they were. I took the screenshots myself. They were questioned last time in the hearing, so I asked Aaron, can you certify that these are real pictures? That is all. They were my evidence. That's what I provided. He just confirmed. I actually sent you a screenshot of this. If you want something more official, unfortunately, because the elections are happening now, you will have to request it. So no, the administration did not provide this. I did.
My apologies, Mr. Gandalf, but I will be going forward with Ivan's evidence, as it appears that he provided it himself without Aaron's assistance.
Your Honor, we have a second objection to file to this. This evidence was never properly submitted to the Google Drive. We were never able to review it, despite explicitly requesting for it. So
I apologize, Mr. Gandalf, but we made very much sure that that image is in fact in the Google Drive under their evidence.
For our help, could you direct us where that is?
Of course. Of course. Can I please get one of my justices to please get me the exact location?
I'm looking for it now. I'll post the link in the chat.
Thank you so much, Catherine.
Thank you.
Do I wait or what's going on?
Could you just wait a quick moment, Ivan? I really appreciate it. This is also for the clerks, if they could please pause the time if they have not already. Vanessa, I know you were in charge of it. Do you happen to know if you have faster access to it?
The screenshots aren't named, so I think I would still have to look through them. Yeah. I'm looking through them right now.
Oh, you're all looking through the photos? All right, thank you.
So what I'm noticing is I did send them to you, but I sent 2 files. I don't think the one where they were specifically was, I don't think you guys put it in the proper folder. There is screenshot 37 where it's basically just Aaron, yeah, I certified that these things are legit. That's screenshot 37.
Does any of my justices have an update on it?
It's looking like we did not put it in there.
Seeing that we have failed to provide it in, we will be providing 15 minutes for the defense to be able to look at it. That is on our own fault. This is not the fault of the defense or the prosecution. This is on the fault of the board. So we will be providing and putting it in, and we will be giving you all 15 minutes to be able to look it over. Yes, Vanessa.
It is actually in there.
I'll go there. Vanessa, can you please give us an exact location?
Yeah, so if you look on R5663 impeachment formal, parentheses public, you click on that and there's a folder named prosecution. You click on that and you click on discovery. It's screenshot 37. Is that the one that we're looking for?
No, we're looking for the actual, I believe the prosecution had brought this one up. We're looking for the actual substantive donation statements.
Okay.
I greatly apologize to everybody present here today. We will look into it right away. It appears it is failure on our behalf.
Your Honor, the defense would request this evidence be quashed. It's clearly not allowed the permissible time period that the judicial board promised of 24 hours for review. Otherwise, we would ask for a postponement.
I would love to give you that, Mr. Gandalf, but Ivan actually did present to us these photos long before the 24 hours, and it is of our own fault, not the fault of the prosecution.
I understand, Your Honor. It's just our argument would be we were promised 24 hours. Even if it's the judicial board's fault, we should at least be given those 24 hours for proper review and examination. I mean, you're asking me to put together a defense in 15 minutes for files we have never heard of before.
Mr. Gandalf, I do not wish to debate with you on it, but we also gave you an extension on yours, as we originally asked for them on Monday, and we then gave you an extension until Thursday to provide us with your evidence itself, giving the prosecution even a shorter amount of time than we even planned for. We only find it fair that our mistake is being paid for now, and that the mistake of you providing the evidence so much later than we requested would also be taken into consideration at this moment.
If it helps, I can point out which email I sent them to you in.
That'd be greatly appreciated, Ivan. Thank you.
Yeah, so the title of the email that I sent it to you guys was on Monday, March 11th, March 1st, 8 a.m. It's discovery request and evidence. It's the evidence for hearing folder. And there's a screenshot folder, and then they are separate to the screenshot folder. I don't know why they are, but they are.
Are they the two that are in a separate, that are not in the folder? Are they the two that is?
Well, they're in the folder as a whole, but there's like a subfolder, and they are not in the subfolder, but they are in the greater folder.
Yes, they're the two that are currently standing outside of it, correct?
Yes.
Understood. Can I please get someone on the board to please transfer that over to the public files?
It appears that the files... Yeah, okay.
Thank you so much. Due to the judicial board's mistake, we'll be giving you all 15 minutes in order to overview. We will come back into session at 5:40. Thank you.
Seeing as I'm the one who was on time, can I know how much time I have left?
Can I please ask the clerks to give Ivan his time?
Oh, you have 4 minutes and 52 seconds.
All right, thank you.
Thank you. My greatest apologies on behalf of the board. Board, if you wish, you may turn off your cameras. You do not have to stay until 5:40.
A question, Your Honor. I'm looking at this link that was posted, but it seems to be the same discovery link. Can I be notified which one of the emails is it screenshot 37?
Kai, do you have an answer for that?
Yeah, so I believe that let me go back to the discovery thing. I believe that it's screenshot 2 and screenshot 3 within the discovery folder.
Thank you.
Yeah.
Just a reminder to everyone, in case they did not hear, we will be returning back into session at 5:40. If I can please have everybody return, the time is now 5:40. The 15 minutes that were allotted have now expired. Continuing forward, does anyone wish to bring anything up before we continue forward? I know someone must have something to say. No. No. Again, the greatest apologies on behalf of the Judicial Board. This is definitely our mistake. We are definitely talking about throughout this entire 15 minutes allotted. As of right now, we do not believe it deserves a delay. But if anyone wishes to contest this, please feel free to. But as of right now, we do not believe this is something that deserves to be delayed.
Your Honor, the defense is ready to proceed.
Thank you, Mr. Gandalf. Seeing that the defense and presume the prosecution is ready to proceed, Ivan, are you ready to continue your time?
Sure, I am ready.
All right. Are my clerks ready?
Yes.
All right. Ivan, on your first word.
Yeah, so it is very clear. Article 5, Section 1, Subsection B states the members of the Election Commission must not have made a financial donation to an ASUCI Canada for elected office within the preceding year. I provided the image was certified. That's a fact. There is no argument against this. The elections commissioner donated money to the campaign, to his own campaign, to his slate's campaign. That is a fact, and was then appointed to the election commissioner position. That is a fact as well. With that, it is purely based on constitutional basis why we are removing them. And here's the fact with the deputies. October 29th, the signatures received the proper amount on Saturday 24th. This is the signatures for the recall. The Elections Commission failed to do their job at probably calling a special election. Article 10, Section 2 specifies the Election Commission has all authority for ASUCI elections and related activities. Furthermore, the Constitution makes almost no specification of the powers of the Elections Commissioner. Wait, sorry, it's not. That's not what I was trying to say. So it is very clear the Election Commission has 3 days to call a special election within once they are certified and once they have the threshold needed. The Elections Commission, by their own admissions, if you look at what they presented during meeting minutes, which first of all, I want to note there are no timestamps in any of this, so I don't even know really if these could have occurred. But look, there was no meeting that week. The threshold was met October 24th. There was no meeting that week at all. There was a meeting next week within the Elections Commission. That is true. However, by next week was too late. They were supposed to do it within 3 days. They were constitutionally obligated to call a special election within 3 days. They did not do their job. Instead, what we had was the commissioner, not the commission, which it clearly states the commission has to call a special election, basically trying to, I don't know what on earth he was doing, trying to say he'd call the election when there was no official meeting of the Elections Commission until the very next week. So they did not properly call a special election, and that is an argument based on the Constitution, like I stated above. They did have a meeting the week before, and as far as I can tell by their own minutes, they basically could not care less about the special election. They talked about the election code, and that's literally it. They failed in their duties. They failed in their responsibilities. They violated direct democracy, and they violated democracy itself. And apparently they didn't even care to talk about it in the next meeting. So they should be removed for those reasons. The deputies are accountable. This is us holding them accountable. They failed their job, and now we are impeaching them and trying to remove them for failing to do their job as they were supposed to. That is a fact, and the deputies were complicit in everything. They did not step up. They did not voice concerns. They did absolutely nothing. They didn't even discuss it, it appears, by their own minutes. This conversation we've had in the pre-hearing about political discrimination, I was surprised it was even mentioned, to be honest. Why? Because as long as I've known the defense has been screaming yelling about political discrimination this entire time I've known him. So I was surprised that they even talked about it here. But there was no political discrimination. I provided evidence in my own email on search terms about what happens when you type in Friends of Peter, Republican, Conservative, And there's basically nothing that pops out that's really relevant to anything. Republican pops out. I get, for whatever reason, I'm subscribed to Cal Matters, a news organization, and that's the only thing that pops up when it comes to Republican. Everything else, there's like virtually nothing that comes up. There's never been any evidence of discrimination in my emails. It has just never happened. I do take political discrimination serious if it were to have actually happened, but there is no evidence. It's literally just someone saying that there was political discrimination as they know, and they can't prove it. They literally just can't. I provided everything that's relevant, that mentions the search terms. Some of the stuff I wasn't able to provide, and it's mostly when the search term bylaws and judicial board. If I give you everything I have for when you type in bylaws, you will literally get the past 7 years worth of legislations. As those, I get an email every time the bylaws, anytime someone submits a legislation, everybody cites the bylaws for reasons they're submitting the legislation. So that's like literally like 700 emails of just pure legislations and other stuff that's completely irrelevant to the case. Same thing with judicial board. Okay.
Thank you, Ivan. We are now proceeding with the 10 minutes that will be opening statement of the defense. Mr. Gandalf, whenever you're ready, on your first word.
Give me a quick.
Of course.
Your Honor, may it please the court. Today's case is the epitome of unfettered, unmerited majoritarianism. As we will demonstrate today, the defense's arguments, the prosecution's arguments do not even nearly approach the Yan requirement of beyond a reasonable doubt. But even worse than that, today will illustrate a creeping taint of insidious discrimination plaguing the prosecution's case. But before we head into substantive legal arguments on the evidence, allow me to first illustrate our context. Article 10, Section 3 of the ASUCI Constitution explicitly outlines the responsibility of the Elections Commission, which enumerates numerous requirements on conducting elections. On one hand, we have Ryan Pavey, the Elections Commissioner, who has faithfully fulfilled all of these requirements. As we speak, we are lawfully conducting the ASUCI elections despite numerous attempts by the Senate to harass and prevent the defendants from doing their jobs. We have his deputies, who are charged with nothing more than merely associating with Pavey, and who have remained impartial and independent per their constitutional duties. But on the other hand, let's pivot to the Senate. The Senate alleges these tall-tale claims of negligence and abuse, and yet have failed to even conduct the most basic fact-finding hearings. Worse, not even a single senator who voted in favor of this impeachment legislation would show up today, despite numerous requests. The administrators key to the Senate's prosecution will not even show up to offer testimony for the first charge on donations, and we were never shown that so-called smoking gun of official donations that would specifically indicate Ryan Pavey donated to another individual. The lack of evidence is clear, but worse yet, it demonstrates a presumption by the Senate that this board will merely rubber stamp any item they pass. As a result, recalling the politically divided but unanimous court in Yan, we respectfully ask that this court find the defendants not guilty on all charges.
Thank you, Mr. Gandalf. If you wish to use the rest of your time, you're more than welcome to. It is up to you.
The defense rests its opening statement.
Thank you, Mr. Gandalf. Seeing that the defense has made their opening statement, we'll be moving on to the next section, which is the prosecution has 1 hour to present evidence and to call forth its witnesses. Mr. Gandalf, the defense will be given 20 minutes of cross-examination time. At any moment that you wish to cross-examine, please let us know. Mr. Ivan's time will be stopped and your time will begin. Are there any questions about this moment?
Yeah, so like for this part, do I just like go over what the Constitution says, go over the screenshots, or what?
Anything you wish to fully make your case, Ivan, now is the time. This is when you present absolutely everything you wish to present. This is the time they call on your witnesses. You use this time as you wish to make your case, and you have 1 hour to do it.
I suppose, do I, do I just like tell you guys which picture to look at or something? Or
Screen sharing privileges are open. You are more than welcome to screen share. If that is something you do not feel comfortable with, you can tell us which screenshots you want us to pull up, and we can pull it up and screen share it ourselves. When you're ready for a witness, you could call upon your witness, and we will see if they are here. And if they are, we will have them become a panelist, and we will allow them to open up their camera.
yes. All right, give me some few minutes.
Let us know when you're ready.
Well, since I have an hour, I'll just screen share now. So the defense keeps alleging that I haven't shown proof about the donations. I don't know what he thinks this picture is. That's Ryan Pavey, $167.52, saying he donated that amount for Facebook and Instagram advertisements. That is a donation. That is by definition a donation. And the Fund the Clubs, the slate, there it goes again. He donated to his campaign and to his Fund the Clubs slate. If you want to question what a donation actually is, we can go to the elections code, and they have a definition of what a donation is. It's basically a donation is any financial donation as long as it was any financial or something else was provided that was given to you outside of a family member. I have that. I'm just trying to pull it up so you guys can see it specifically. Sorry, my internet being slow right now. I have no idea why. Responsibilities, financial reporting, here. The term donor means any individual except an immediate family member. That means he counts as a donor. He donated to himself and he donated to a slate. That's by definition. That is very clear in the governing document. It's literally what it says. So yeah, I'm a bit frustrated that apparently, sorry, I should probably close my emails. So yeah, I'm a bit frustrated that the defense keeps alleging that there is no proof of a donation. Well, this is literally what it is. I don't know how more clear I can get this for you to understand. This is proof. You can go to screenshot 37, certification by our tech guy. That is a donation. It's not something to argue to basically say that these aren't evidence of a donation is to deny the concept of reality itself. The second evidence I will provide is the defense's own meeting minutes that they provided. There's a meeting note on September. This was not relevant, and there was one in November. The special election was called the 24th and the 25th. Well, that's when the petition reached the threshold. They had no meeting. How can you call a special election when you had no meeting? So I don't know. Like that's clear. It's in their own minutes. It's in their own documents. That's what it is. The other, I will go to the Constitution to spell it out for you guys again. You guys can see the Constitution, right? Sorry, I know it gets hazy when I go through my PDF. You guys see my Constitution?
We are currently looking at minutes, Ivan.
Okay, sorry, I know share screen gets weird. Yeah. To Article 12, direct democracy. Recall. Recall is a power of the undergraduate students to remove an ASUCI official. The following individuals are eligible for recall: executive officers, senator, SAG, and all justices.
Ivan, as per judicial board rules, we can ask questions during this time. I just want to ask a point of clarification. Is this the old Constitution or is this the new Constitution?
This is the Constitution we have been following for the past 4 years. There is a new Constitution that will be proposed, but that hasn't been adopted, so it is not relevant to this case at all.
Thank you. I'm just making sure that you are using the same Constitution. Thank you.
Yeah, this is the same Constitution. It is very clear. Within 3 days from receiving the signatures, the Elections Commission, not the commissioner, must validate them and call a special election if the requirements are met. It is clear. It has to occur within 3 days. They did not meet They had no meetings. They did not call it within 3 days. That is very clear. I don't know how much clearer that could be for you. That is, it is definition. It is proof. They didn't even discuss the elections commission and within the next meeting that they had. We will wait for Aaron Stephanie to approve going into the documents, special election timeline. By then, this was too late. It was already too late. They had already failed their obligation, and none of the deputies spoke up. None of the deputies said anything. They just sat back, were perfectly fine with everything that was going on. And the only time they cared was with the elections code. Well, apparently you only care with the elections code. Also, I'd like to point out there's not even an attendance for this, by the way, which is shady on its own. Let's see what else I can go over for you. I guess I will address political discrimination. Friends of Peter. Does your email requesting things? This is an email from 2018. I don't even know why that pops out. I think it's just because it says Peter the Anteater several times. Republican. This is an example of the Cal Monitor article says typical conservative. This is what pops up. Talking about Republican. That's it. There is no further discrimination. There never has been. There never will. Well, I'm not saying there never will be because I have no idea who will get elected in more recent years. There is no evidence of discrimination. There just isn't. With this search word discrimination, this is a call to action that local community members are calling for us to take a stance on. That's one of the only things that pops up for discrimination. Same thing, call for actions, discrimination. The reason I feel like I have to walk over this with all of you is just there's just so many allegations, so many denying of the truth. I'm feeling that I literally have to walk you and hold everyone's hands through this process. Bylaws, this is what I meant. Well, actually, these are mostly you guys' job applications, to be fair, see Kai, Catherine. So I wasn't going to share anyone's job applications because that's private information. I just wanted to make sure you guys saw. That's what pops up when I put bylaws. Judicial board, same thing. This is actually our more recent correspondence with you guys. And same thing, I get a bunch of job applications. Let's go back to what the memos. These were orders by upper administration. That's what pops up when I put memos. That's literally it. These were, we are a department within a department, so of course we have to follow UCI policy. And this is us basically telling us that we have to follow UCI policy. It spells it out, it goes over past legislations, and it's all it's really doing. This is an injunction by Judicial Board when the defense was Chief Justice, basically telling us that we don't have to follow university policy, which was absolutely crazy when we are considered we are a department within a department. Of course, we have to follow UCI policy. I have no idea what anyone else would think that we do not have to follow university policy. Let's see what else I have. At this time, I guess I will like to call Michelle to the panelists.
Wonderful. If I can ask the clerks to pause the time while we set up Michelle coming in. Let's see. Michelle. Ah, there she is. Someone already moved to the panelist. Thank you. Thank you. Does Michelle have privileges, Catherine?
Yes, she's been moved to panelist, so she should be able to unmute and come on now.
Wonderful. Michelle, if I can ask you to, there, thank you. All right. If I can have the clerks begin time again on Ivan's first word.
Yes. Hello, Michelle. I saw you earlier today for completely unrelated reasons. What is your official position in ASUCI?
This year, I'm serving as the ACCI president.
Are you the chair of the executive cabinet?
Yes.
Is the election commissioner a member of the executive cabinet?
Yes.
Have you invited the election commissioner to all executive cabinet meetings?
Yes.
Okay. Have they attended any of them?
No.
Have you attended every meeting?
Yes.
And you've never seen the elections commissioner attend a meeting.
Correct.
Have elections ever been discussed in the executive cabinets? In the executive cabinet?
Perhaps just when the legislation passed to impeach elections. As of right now, I can't recall if we have ever discussed elections besides that point.
Okay.
But I can always review the minutes too.
Yes, and you provided the minutes for us to see already, right?
Correct. Yes.
And you have accurate attendance of all those meetings, right?
Yes.
Do you think the elections commissioner failed to do their job by not attending the elections, not attending the executive cabinet?
I would say, even though it is not outlined that it's part of the responsibility, I will say that other officers that are not voting members also do attend these meetings as they are advisory.
Correct. Do other advisories frequently attend these meetings?
Yes.
Hold on, I'm thinking of more questions. That's basically all I have. Does she go back, or like, do we move forward? Or
If that's all you wish to have, Ivan, we will just be asking Michelle that that we thank her for her time, and that we will be asking you to turn off your camera. Oh, yes, Mr. Gendal.
Is the defense allowed to cross-examine?
You're more than allowed to cross-examine Mr. Gendal. Yeah,
Your Honor,
after you,
may I
Mr. Gendal.
proceed?
Yes,
Or
you
is
may proceed.
Thank you, Your Honor. So, Michelle, I reviewed a few of the executive committee minutes, and it seems that there was no actual substantive business related to Ryan Pavey or the elections in general, and you seem to reaffirm this in your testimony. Would you say that's accurate?
From my memory, yes.
So you do admit that there was one period of time, specifically the election commissioner's impeachment, that they were discussed. Could you explain that a little bit for this court?
I would have to look back at those minutes. So if I could pull them up.
I believe you're breaking off a little bit. Just from your memory.
Sorry, what was your question?
I'm simply asking, what did you specifically talk about when you talked about the election commissioner impeachment?
I think we reviewed the legislation that Senate submitted and voted on. We discussed and thought that those allegations were correct, and then we approved it and moved on.
Okay, that sounds fair. So similarly, there was a judicial board impeachment recently. And one of the fundamental claims made by the defense is insidious discrimination. When you ran the judicial board impeachments, did you ever actually notify those defendants of their trial?
I would have to question relevance on this one.
I'm attempting to establish a relevant pattern of events that is related to a series of insidious discrimination, clearly related. As the prosecution stated themselves, this is part of a series of impeachments against officers. It's completely relevant.
It's not relevant to the impeachment of the Election Commission. It is relevant to your own impeachment.
Prosecution, how can I establish a pattern of insidious discrimination if I'm not allowed to ask them about relevant events?
This board will allow Mr. Gandel to continue.
Thank you, Your Honor. Would you like me to repeat the question?
Yes, please.
One of the fundamental claims made by the defense relates to insidious discrimination. When you ran the judicial board impeachments, did you ever notify those defendants of their pending trial?
I don't believe that the impeachment is run by me. I believe that it was initiated by Senate and approved by the executive cabinet. And I don't believe that there are trials for all of judicial board when they are impeached, from my understanding of the Constitution.
So would you deny sending an email asserting that you held a lawful trial and agreed to remove them from office?
Sorry, can you repeat that?
Would you deny sending an email saying that you held such a hearing and removed them from office?
I'm confused by your question.
Would you deny that you sent an email asserting that you held a hearing approving their removal from office?
I would not be able to verify right now if I sent an email regarding a trial,
A hearing, a trial?
a hearing, correct?
Okay. How quickly did you conduct said hearing?
I will have to question relevance at all.
I
Hearings for judicial board aren't listed anywhere. It's not a thing.
Yeah, yes, it is. That's how you remove the judicial board. I mean, we can get into
Where is that stated in the Constitution?
Your Honor, is it relevant for me right now when I'm attempting to cross-examine a witness to get into legal arguments about procedure, or can I continue my questions?
We would like to keep hearing these questions as the board is also questioning the relevance. We'd like to see this connection come further.
May I continue? Thank
You may,
Your
Mr. Gandalf.
So I'll repeat the question, Ms. Malari. Did you hold a hearing, and how quickly did you hold it?
A hearing was not held for
the judicial board. There was no
Correct.
hearing.
Correct. Because who is supposed to conduct the hearing if
so
judicial board is impeached?
The ASUCI Constitution states you have, though, and you stated in the email that you sent out that there was a hearing held and that you approved the removal of the judicial board. So my question is, would you deny what you sent in the email was accurate of the events that took place?
Which email are you referring to?
You sent out an email. Would the court allow me to relevantly discuss this this email, despite the fact it was not submitted as evidence?
I'm gonna have to I have to deny that, Mr. Ganda. We would like it to stay to this.
Okay. So again, I'm wondering, did you notify them at all? Yes or no?
I notified. Okay, here I will explain my understanding of what happened.
Thank you.
Senate passed the legislation to impeach judicial board. Executive cabinet received it. Executive cabinet, specifically the voting members, discussed it. We did not veto it, so we unanimously approved it and took a vote. And in that, we notified the judicial board at the time that everyone was in the affirmative to impeach judicial board.
Excellent. Can you explain some of your reasoning to that?
My reasoning to the process?
The impeachment.
The impeachment? It was stated in the legislation, so I would have to go back.
So you would say the legislation repeated your reasoning?
I would have to check before I say yes or no.
Your Honor, can I ask her to check, because this is relevant to arguments I'm going to make during my primary
Mr.
argument.
Gandalf, the board and I are starting to feel as though there are some things that are starting to become a bit more irrelevant as we go forward. If you can narrow it back towards the
This is my last question related to this.
I would also like to ask a question, as judicial board members can ask a question at any point within this. So when it comes to the impeachment of the judicial board, Section 6 of Article 8 states that the executive cabinet, the Senate may impeach all justices at the same time by a unanimous vote. The executive cabinet may then remove the justices from office by unanimous vote. And that's what it states for impeachment of justices. However, all other impeachments do state that judicial board needs to do a hearing.
Yes.
I don't believe there's any other part in that there's no other part within the section of Article 8 that states that there needs to be a hearing for it. So, and you stated that within the Constitution, it says that they need to do a hearing. So I wanted to know, where within the Constitution are you finding that they need to do a hearing for the impeachment of the judicial board?
The argument I'm eventually going to make is that they want to establish a criteria for having extensive meetings to approve items that don't need so. So, for instance, it seems like Ivan's making a lot of technical arguments in regards to calling the elections. What I'm pointing out is they're not holding themselves to those same procedural standards in RONR. So clearly, for instance, there can be allowed the motion to ratification for elections. And I'm trying to show that there's a precedence behind this, and that they're trying to pick and choose where they want to establish procedure. And that's going to be an argument I make later. but I want to establish certain key facts during cross-examination, which I feel is completely fair for the defense to make.
Mr. Grando, I'll allow you to continue, seeing that if you can quicken this establishment, we'd greatly appreciate it.
Yes, of course. So moving away from the judicial board impeachment, I reviewed the executive committee meetings, and when it comes to Ryan Pavey, you've already stated that there was only about the elections impeachment. Can you explicitly name at least one other relevant item related to the Elections Commission that ever came up during any of the executive cabinet meetings outside of impeachment?
As of right now, I don't think so.
Thank you. Per the definition in Knight, which you were aware of, you were part of the Senate at that time where there's discussion on membership. Was it to your knowledge that the executive cabinet often included individuals that were not voting members, such as, for instance, Senate President Faith Chua at the time?
Sorry, your question is?
My question is, was it normal in the past for advisory members to be at every board meeting?
That would have to be speculation because I don't know how previous executive cabinets ran.
Okay, thank you. A few more questions. Part of the memo that was sent out had to do with administrative review. At any point have you been contacted by Stephanie Ginkle or any other administrator regarding review on legislative items?
Not that I know of.
Perfect. That's all the questions the defense has.
Thank you, Mr. Grando, and thank you, Michelle. Ivan, the time goes back to you.
So I can ask Michelle more questions.
If you so wish to.
Yes. Does the Student Advocate General appear at your meetings?
Yes.
Has there ever been anything relevant to the Student Advocate General's office during these meetings?
In my perspective, not necessarily, but if the Student Advocate General wanted to partake in those items, then in that sense, it would be relevant to that office.
All right, thank you. That's all I wanted to ask you, Michelle. Thank you for coming. I know you probably have much better things to do on a Friday night.
Thank you, Michelle. If that's it, I'm gonna make sure from the defense and from the prosecution that is all they wish to ask of Michelle before we release her.
That's sufficient.
All right, thank you. Ivan, I presume that is also.
Yeah, fine.
All right, thank you. All right, Catherine, if I can ask you to move Michelle. Thank you, Michelle. We really greatly appreciate your time. Ivan, you're more than free to use the rest of the time that is left for you. I'm gonna ask the clerks quickly. How much time is left for Ivan in his claims?
48 minutes and 41 seconds.
You still have 48 minutes, Ivan, if you wish to still make an argument or present more evidence or state anything else. You do not have to use the full time if you do not wish to. You may use this time as you wish, so long as it is relevant to the case.
Yeah, so first of all, I must apologize. I do not have Robert's Rules of Order PDF thing, even though I do know it's available online. But hearing as the parent of the defense is going to make several instances about Robert's Rules of Order, I'll go over them. I don't have anything. I can't. Well, I have the book, but I can't show you my screen with them. So first of all, Robert's Rules of Order, as we know it in this government, we use it to conduct our meetings. That is the way we've been operating under for this entire school year. And that's all we do. We just use the motions. We just use the stances in our meetings. And that's it. We don't really apply it to anything else. The defense has alleged in the past that we pick and choose the rules we want to follow. We don't do that. They argued a whole thing about due process, which I find to be inherently problematic. Robert's Rules of Due Process isn't mentioned anywhere in our governing documents. It is, however, mentioned in Robert's Rules of Order. And what it says about Robert's Rules of Order is this. It just says if there is something committed, a defense committee must investigate. And once the defense committee charges the individual, a trial committee has to give the defense their due process. We do not have a defense committee at all. That's not a thing in our government. It just doesn't exist. So I don't know how they even go off and try to apply it to the way our government works When it comes to a trial committee, if he is saying that we denied them the right to a trial, that's inherently problematic because, well, we use the word hearing. So they're saying that we denied the defense a right to a trial. To be honest, I don't know what that means because as far as I'm concerned, this is the trial. This is the hearing. You guys are allowing the defense to come and speak to you and argue his case. Say that we are denying their due process is basically saying that we are currently not doing what we are doing. We are simply here talking about something else. This is the due process that he's alleging we are denying right here, right now. So I don't even know why would they even allege this to begin with. That is what Robert's Rules of Order states. And first of all, like I said before, Robert's Rules of Order is intended for us the way we conduct our meetings. In Robert's Rules of Order, it actually says that it is us, the people in this government, who define what our bylaws mean and interpret our bylaws. So as a Senate, we interpret the bylaws as we only use it for our meetings and handling motions during our meetings. That is basically it. That is the minimum we do use.
Ivan, may I interrupt you a quick moment
Yeah.
for a question? As you're saying that it is the way the Senate uses it, does that mean that the defense and Ryan Paving, all of them, would also be under the same interpretation about Robert's Rules of Order? Is there any way you can tell us that it is that how you conduct everything, or is it up to interpretation for every individual?
So it's slightly up into interpretation, but the bylaws is inspired by Robert's Rules of Order. So the bylaws kind of just modify and like literally just spell out some aspects of Robert's Rules of Order. So that's in their bylaw. If it's in the bylaws and it's in their elections code, they have to follow those procedural things. If it is not mentioned, I don't believe they should follow it. So to give you an example of this, and there is an example in the ASUCI bylaws. Here, let me share screen real quick. So debates and reports shall be modified from Robert's Rules of Order in the following ways. It's basically saying we got our debate and procedure reports, which is all of this, that's spelled out Robert's Rules of Order. We simply just modified it for it. So they have to follow the governing documents, and the government documents are inspired by Robert's Rules of Order, but they only have to follow what is specifically written. If it's not written down, they don't have to follow it under my interpretation. Really, as you guys are the ones who have final jurisdiction on interpretation of the governing documents, it is really up for you and Judicial Board to, I guess, settle this, if that is what you guys seek to do. The one thing I would warn, and the one thing I have always been against following Robert's Rules of Order strictly, is when you apply it to a democracy and you apply it to a government body, is basically creating a knowledge test in a democracy and in a government. You are basically saying if you want to participate in our government, you have to pass this test. And to me, that is the most dangerous and detrimental thing that can ever happen to our government. Because if that happens, you are literally not making this government accessible, and literally nobody would join. Robert's Rules of Order is 700 pages. Do you really think all interns, all senators, everyone else would even bother reading this if this was a requirement for them to be hired in this government? That would be the largest deterrent to anyone ever running for Senate or for any executive officer, any executive. So which is why ruling that Robert's Rules of Order is applicable to everything is absolutely 100% dangerous. It should only stay within our meetings. So that's my sense. We shouldn't use Robert's Rules of Order, only for our meetings. The reason I do make some Robert's Rules of Order arguments, and I make Robert's Rules of Order arguments and I make Constitution arguments. They're kind of not, it's Constitution, Robert's Rules of Order. Like I said, the Elections Commission, the Constitution is clear, is the Election Commission has to call the special election. There is no evidence the commission called the special election. If you apply Robert's Rules of Order, it gets even more stricter. It means they have to have meeting minutes, they have to have meeting agendas, they have to have a vote count, they have to have attendance. The own defense didn't provide any of that. So if you follow Robert's Rules of Order, well, they didn't do what their job was supposed to be doing. But even then, if you don't follow Robert's Rules of Order, they still didn't do what they did. They still didn't do what they were supposed to be doing, as calling a special election. It's double. They failed to do Robert's Rules of Order, and they failed to do the Constitution, abide by the Constitution. And if you go to Ryan's Pavey's donation, that is 100% against the Constitution. I don't even know what Robert's Rules of Order says about that. denying due process, again, not mentioned in governing documents, it's mentioned in Robert's Rules of Order, and so on and so forth. Interestingly enough, hold on, let me look at my notes real quick. Yeah, so even if you notice this, the defense is alleged we denied them of due process because we didn't follow Robert's Rules of Order's ways of doing due process. Even if you accept that argument, which I think is inherently faulty at best, if you even follow Robert's Rules of Order, the defense is also alleging that they did call a special election, which by applying Robert's Rules of Order to their own standards, since they want Robert's Rules of Order to apply for everything, they did not call the special election properly. It's literally the definition of selective and rule enforcement within their own argument. They seem to will potentially make later on arguments on why the Senate is being selective in our arguments. I don't know what they're alleging. I would have to wait to hear them out for that. But it is very clear. If you want to, we shouldn't have this. Look, this is my end notes for this. Number one, we should not follow Robert's Rules of Order. Number two, if we do follow Robert's Rules of Order and we do follow it strictly, the defense's argument still isn't holding because they didn't have, if they follow the Robert's Rules of Order and call the Elections Commission a board, and they don't have the meeting minutes and they don't have the meeting agendas for that week. So the special election was still not properly called in the special election. So the Elections Commission still didn't properly call the special election following Robert's Rules of Order. And the other thing tagged onto that, their main argument of due process is based on Robert's Rules of Order. They're basically picking and choosing when to follow Robert's Rules of Order themselves. My arguments are based on the Constitution. I can also make arguments based on Robert's Rules of Order, which I have made as well. And yes, that is basically what this is about. I went through the defense. I made my case all based on the Constitution. I showed you my Robert's Rules of Order. I told you my stance that we shouldn't follow it as strictly, and I told you this: if we follow Robert's Rules of Order strictly, it'll be the worst thing that ever happened to this government. It will make this government the most inaccessible government we've ever seen. And even then, the defense, by their own definition, if we followed Robert's Rules of Order, they didn't follow it either. Well, they didn't follow it at all. They did not follow it. To me, that is very clear. I wish I could have the PDF of Robert's Rules of Order, like go over it with you guys, but I do not. That is basically it for this, for now. So.
Thank you, Ivan. Seeing that is the end of the prosecution's time, we will be proceeding into the 30 minutes that the Judicial Board has to question. After that, we will move into a 30-minute break, and then we will continue with the defense. May I have the clerks ready on time for the Judicial Board, just so we stay on time with ourselves? I'm gonna take that as a yes.
Yes,
Thank you. All right. We are commencing the 30 minutes that the Judicial Board has to question the prosecution. If anybody in the board has any questions, please now present them.
I'll ask a question. I just want to clarify the main argument towards the deputy commissioners, Ivan, is due to neglect of duty for not calling the special election. Is that my understanding? Is that correct?
Yes.
Okay. And then there's nothing else about the deputies, not Mr. Pavey himself, but anything about the other commissioners regarding anything.
The way I see it, they were complicit in everything the commissioner did outside of the financial donation, as they could have easily just stepped up and spoken out against the commissioner. They never did. If you want to follow Robert's Rules of Order, they could have overruled the commissioner, and they didn't do that. So,
thank you, Ivan.
Ivan, in the same line with Giovanni, there we can see this as a claim as someone not stepping up against their boss. Mr. Pavey is obviously the boss of the commissioners per se, and so can you tell us? I understand that you told Gio, but in the Senate, is it common that the people underneath the head is able to proceed with things, or is it most likely that the boss, in this case, the commissioner, proceeds with everything and everybody follows suit?
So the way we generally do it in the Senate is basically I am just the face and I guess the chief communicator when it comes to admin and the rest of the executive offices. I literally tell them this: you have the freedom to do whatever you want. Just I guess if you need help and need any advice, come to me. You are free to do whatever you want, and I will advise you. If I think you're doing something you're not supposed to, then I will go out and tell you that as well. But senators have freedom to do whatever they want for the most part. I never tell a senator, well, I rarely have ever told a senator no. I just advise them. I tell them, do they understand what they're doing might be interpreted in certain ways, but I never tell them no.
Ivan, would you then believe that it falls upon the Senate's own responsibility to make sure people are following these rules? Because to my understanding, and please correct me if I'm wrong, to my understanding, your stating is that these people are leaving it up to their own interpretation, that they could do things. They could come to you for advice if need be, but you leave it very much up to them. Does that appear to you that it creates some sort of gray area, which is why we are here today? Do you believe this is a fault of the Senate, or do you believe this is up to their own duty to make sure they uphold the rules?
The way I see it is gray area, as long as they're doing what they're constitutionally and obligated to do by the bylaws, they are fine for the most part. Wait, sorry, can you repeat your question a bit? I want to make sure I'm answering.
Of course. So what I'm essentially asking is if you in your previous answer told us that you really leave it up to them, that they can take care of their own commissions and all that on their own, but that they can come to you if they need any advice or if they need help in any way. So it very much appears that the Senate has created this gray area that can lead Ryan Pavey into doing what he has done, and what the Senate is claiming that he has broken the rules of. Is it not on the fault of the Senate itself for not helping him make sure he's on top of things, or where does the Senate fall on that? It's not an accusatory question. I just want to have some clarification in this.
Yeah. So basically, the way it generally works, senators are independent. They can do whatever they want. If they want a legislation passed, they have to get the vote of the entire body. We move as a body. They have to get the majority, 2/3, or whatever the threshold is. Generally, we tend to not, besides unless it's crucial, we tend to just let other offices kind of, let me put it this way. If something bad is happening, we find out about it, and then that's when we kind of have to step in. The Elections Commission, if they're following the same rules of what we do, they still needed the deputies as well to agree to what the commissioner did. If the Senate was the one who didn't call a special election, it would have been the fault of the entire Senate, as we all have to approve it. That's the way I interpret it. And the Elections Commission basically went out and then, that's what I'm trying to say, the group moves together. The Senate always moves together on legislative stances. When it comes to reports of the commission and other actions of the commission, they have to move together as well. The commissioner cannot act alone. The commission did not move as a group. They did not call a special election. The commissioner, I guess, tried to do it, but that was not within his own will. As a Senate president, I do not have power to pass legislations on my own. That's not a thing. That's not a thing. That's basically my response to your question.
Thank you. Samuel?
So you're essentially, to me, it seems like you're comparing how the Senate acts to the Election Commission. So I just want to ask, why do you think it's fair to compare what is essentially two different bodies of the ASUCI government with two different, like they have their own different ways of acting and carrying out their business in the bylaws, Constitution, and the election code?
they have different responsibilities than we do, but at the end of the day, they are their own body, and the bodies have to move together. That is what the Constitution states. So we are similar in the aspect that we are a body that has to move at this. We are different bodies that have to have the consent of the people in those bodies to move and to do actions. That is really the only actual similarity, and that's just the way the governing documents just kind of have it spelled out. To be honest, that's yeah.
So I guess just to, sorry, I have something else. So you bring up how, like, in the Senate, right, if a senator wants to introduce legislation, they have to get a majority vote, right? That's how it works. That's why you say it moves like a body. Well, at least under the ASUCI elections code, for the deputy election commissioners, it lists the only duties it lists for them are to verify the eligibility of candidates, promote elections in advertising, campus media, and take minutes. So if that's listed there, that those are their duties there in the governing documents. How did you really expect them to, or how did expect them to have stood up against Ryan Pavey and acted on their own accord, especially since it also states that the duty of the elections commissioner is to instruct them. So the elections code seems to be stating that they are subservient to the elections commissioner. So how are you exactly expecting them to move forward with the special election on their own accord?
For two reasons. One, the Constitution does have them as a body. The elections code is different, but remember the hierarchy of rules. Constitution is above everything else. Elections code here. So the way I interpreted what they should have done and what they should have moved is the moment the threshold was reached, they should have immediately called the meeting. Didn't have to be a long meeting, and basically agree and make the timeline and then forward it to the Senate. That's the way I believe they should have moved. I don't know why the elections code only says that, but that's not what the Constitution says. The Constitution is very clear. It is the elections commission, not the commissioner.
Thank you, Ivan. Catherine?
So would it be correct in assuming that it would have been down to the commissioner to call the meeting for the elections commission to be able to call then the special election?
Two answers. First, yes. And if you want to add Robert's rules of order to that, the deputies actually have the power to call the meeting as well. So they didn't do that either.
All right. When it comes to the elections code, because the Constitution has a lot of the responsibilities given to the entire Elections Commission, the elections code is going to be a bit different when it comes to it. How sort of applicable is the elections code? How important is the elections code to what you are stating versus what it says within the Constitution when it comes to the actions of the Elections Commission and Commissioner?
Sorry, can you repeat your question a bit?
Like, how important do you view the elections code to be within your argument versus that within the Constitution?
The elections code doesn't really say much about the recall process that is written in the Constitution. So to be honest, when it comes to the recall processes, I don't think it's entirely relevant. Yeah, no, I don't really see anything in the elections code even talking about the recall process. Oh, and just a FYI about this as well. At the time, we didn't have an elections code, so that's another thing.
Ivan, considering you said that, can you at least give me a guesstimation on when the elections code was added then?
The elections code was struck down by last year's judicial board. The new election, this current one was the one we followed in years past, and it was reinstated about 2 weeks after the recall stuff happened. 2 weeks after they were supposed to call it a special election. Oh, and fun fact, because we had different bylaws under then too, Robert's Rules of Order was more applicable under that bylaws. So
So, Ivan, when it comes to like the roles and responsibilities of the commissioners, are you arguing that they should prioritize what it states in the Constitution for their roles over what it says in the Elections Code?
yes, 100%. You have to prioritize what the Constitution states over what any other governing document states. And if there's a contradiction, if for example, if the bylaw states that our Senate meetings are every Wednesday, and if the Constitution states that our Senate meetings are on Tuesday, since the Constitution is higher than the bylaws, we follow the Constitution, and our Senate meetings are on Tuesdays, not the Wednesday.
And that's an ASUCI thing, or is that just a Senate thing?
That's really just how you interpret governing documents, to be honest.
Yeah, if I can just go off Geo on that. Obviously, none of us are senators and none of us have held offices in the Senate. So we're really trying to understand this community of sorts that there may be unspoken rules in which there are in the Senate and everything. So we do want to clarify those things. So I guess I definitely want to just piggyback off that, Geo, just to get a definitive answer of in the Senate, considering the Elections Commission is a body within the Senate, in the Senate, the Constitution is at the highest priority to your understanding and to the Senate's understanding.
Are you asking me or?
Yes, I am asking you. So to you, the Senate, the Constitution is the peak at the top, and everything from below there is just okay. If it's contradicting with the Constitution comes foremost, and that's the way it is across all of the Senate, to my understanding, from what you're telling me.
Yes, and it's not just to all Senate; it is to all ACCI.
All right, thank you.
I guess just to clarify a bit, we the Senate are the most, I guess, knowledgeable of the Constitution, but that's just because the nature of our jobs is we are, I guess, the final administrative authority. So we have to be like more knowledgeable on it. But yeah, that's the way it goes. Real quick. The second body that's actually supposed to know more than us based on the Constitution is actually you guys. So
yeah. Just before Kat goes, can I get the clerks to tell us how much time we have left?
You have 16 minutes and 18 seconds.
Wonderful. Thank you. Go for it, Kat.
I understand that the Constitution states 3 days. Could this ever be interpreted as 3 business days?
When it comes to that, really, the way it would work is if the Senate will have the, I guess, not initial, but like firsthand interpretation of what that means. But then it would be the job of the Judicial Board to, I guess, correct us. That's actually part of the reason I don't know if you guys know, but we're trying to make edits to the Constitution. That's part of the reason we're doing it, because they're just like small little bits like that get kind of confusing. But either way, the relevance to this is the threshold was reached on a Saturday. The Thursday that happened was like 4 or 5 days later. And that's, again, the commissioner attempted to call it. That was not his job, it was the commission's job to call it.
Go for it, Gio.
I just had a question on the screenshots of the donation. Am I correct when I say those are 2 separate donations?
It's the same one. It's just the way the elections code, like the way you kind of have to do it is you kind of have to, I guess, if you're part of a slate, you have to report the money that you contributed, and then the slate has to report again the money that someone contributed to the slate. So it's like you kind of have to like put it twice.
Okay, so it's just one sum total of that 167 or whatever. Okay,
yeah.
Thank you.
On the idea of slates, part of the defense's argument is, and obviously you have passionately answered back, that there is no discrimination against any political affiliation whatsoever. Would you say, in your opinion, that these slates are politically based slates? Or would you say that they are just things that students choose to group up in, and it just so happens that they are politically affiliated?
Yeah, so again, this is a very personal question to me. There, it's basically the second thing you said, where it's people just decide to come together to run to basically win together. Well, I guess they will formally, I guess, a goal or a plan of what to do when they are in office, but it's always based on student advocacy efforts. It's not really political to begin with. ACCI, we're not supposed to be political, so we don't really follow political standards. It's like when it comes down to it, we care. Our job is to care for the students, and we don't care who or what political body is best for the students. If you're good for the students, that's what we're going to advocate for. So an example would be like doubling the Pell Grant. That's something that's currently being pushed from the Office of EVP. Um, that's just good for students. That's not politically. We don't know who's politically against it, who's politically for it. We're just trying to get it done because that's good for the students. That's the way we advocate for it. So like there really isn't political parties here. There's the slates. I can tell you this: the slates literally like once the elections are over, they just kind of fade away, and nobody cares about them anymore. The only people who seem to care about them was the alleged slate that was discriminated against. Well, the one that they alleged that we discriminated against, Friends of Peter. Um, well, I'm pretty sure you guys have all read the new articles, so there you go. That's the only time a slate has ever really carried on over.
And for those who are here that are not a part of the board but are just attending, could you give us a rough overview of what that article said?
So basically, there were several articles. I think I might have included some of it in the defense. Hold on, let me quickly look. Yeah, so basically what it was, like I said, I've been in. I was part of the election, that election too. Once the election ended, we had a group chat with our slate members. After we were elected, the group chat just died. I don't even think I'm still in the group chat. It never exists. It just nobody knows what happened. Nobody cares, to be honest. But I don't see it, but I'm pretty sure I shared it with you guys. Anyway, so basically what it was basically the Friends of Peter slate, which was a slate 2 years ago, they still acted politically based on their slate. Like they truly took their slate and tried to run it as a political party, and they basically worked together on everything. And there's several like new news articles that were released with screenshots that basically just go over what they were doing. And part of it was actually the screenshots speak for themselves. They literally conspired to appoint the Gandalf here to the Judicial Board. That was a political action. As far to my knowledge, that is the only political party that has ever acted. I guess that's the only political party that actually stayed as a group and acted based off of that group. That has never been done before.
Thank you, Ivan. Does anyone have any more questions? Go for Catherine.
How would the Elections Commission been notified that these signatures had reached the threshold?
I believe usually Aaron, our tech guy, who's a neutral body who kind of does the validation. He's the one who just kind of like tells them and like does it. Like the elections are hard to do, to be honest. It's really like the tech guy doing everything. He's the one who notifies everything. He's the one who sets up the petition because you can't really have a student managing that, and he's the one who validates them. So he's the one who notified the commission that the petition reaches threshold.
Anyone else have any more thoughts? I'll just give it a few more moments. I know questions can sometimes take time to come up with. May I ask the clerks how much time you have left? Oh. One moment.
Sorry, no. I just had a question. Is Michelle available?
Let us check if Michelle's still around. She is here. She has been given talking permissions.
Hello, yes, I am still here.
Hi, Michelle. I just had a quick question for you regarding the executive meetings.
Mhm.
Now I know you mentioned how there are non-voting members present at the meeting. Is that correct?
Correct.
And you invited Mr. Pavey to these meetings
Correct.
every meeting?
Yes.
And
Oh, go ahead.
sorry, go ahead.
Oh, he was included in the correspondence to plan the meetings, and then we use a Google Calendar with the Zoom link and weekly meeting times, and his elections email is always included in the invitation.
Okay. And then you did mention how there is no specific, like nowhere outlined that non-advisory members have to be at the meeting, correct?
Correct.
Okay.
Yes, everything
Thank you,
about everything about executive cabinet meetings would be in the Constitution.
And regarding the non-advisory meetings, and I believe I saw the minutes, but just to clarify, even the non-advisory members at least showed up once to these meetings, correct?
Yes.
Thank you.
Mhm.
Thank you once again, Michelle. Kat, if you could do the thing. Anyone else on the board have any more questions for Mr. Pavey? Not Mr. Pavey, for Ivan. My apologies. No. I'm going to give it 30 more seconds, and if we do not have any more questions in 30 more seconds, we'll move into our 30-minute break. Okay. All right. Seeing that the Judicial Board no longer has any more questions, we'll be moving into our 30-minute break. Feel free to do as you wish with this time. You have 30 minutes, and we will all be back here at 7:17. Hello, everybody. We'll just be giving everybody a few seconds to come back in, and then we'll be starting with the defense. I'm just going to give it a few more moments as we wait for the rest of the associate justices. Before we start, though, Kimo, are you coming for my beard? Is this what that is? Is it an attempt to come after my beard?
Too many long programming nights.
Are you a computer science major?
No, I'm political science, but my research is on AI in social science data. So basically trying to get AI to conform and see if they can get prediction patterns out of certain Excel spreadsheets, essentially, is the layman's way to understand it, I guess.
That's cool.
Yeah, it's long.
Are you an honor student or?
Yes. So just
Yeah.
finished my thesis on the United Nations.
That's super exciting. That's cool.
A quick question. Would
Yeah.
you like, is it possible that I can call my witnesses before going into my arguments, simply because it's pretty hard for me to properly establish my arguments without having first my witnesses?
Yeah, so you can use this hour in any way you wish,
Okay,
in any
thank
order.
you.
Mhm.
Okay,
There's no set order to it here.
Awesome. Okay. whenever
Let's
the
just
court-
give it another moment. Yeah, let's. We're currently waiting, I believe, just on Giovanni. I believe.
And sorry, one last question. Can
Yeah.
I ask like how much time I have left after each witness?
Yeah, you can always ask. You'd always feel free to ask. Mhm.
All right.
The clerk and their time available to you all as you wish. Well, I'm not so exactly sure where Geo is. But seeing that we have quorum, I'm going to suggest we just keep moving forward, even though he was just answering his phone not too long ago. Oh, he sent us a message saying he is leaving and rejoining. How about we just give it a quick moment then?
I just realized my mic was off for that. And I was...
Oh, sorry, Kai. Yeah, it appears Gio's having a technical difficulty, so we'll just wait on him to come back, and then we'll just continue. Oh, there he is.
Here.
Wonderful. Thank you, Gio. All right. So we're coming back in session at 7:20. The floor is all yours, Mr. Gandalf.
Thank you. If it may please the court, I would first like to call a witness. I have several witnesses I wish to call pursuant to the emails I sent out. Ivan, did you receive an email earlier from me? And are you comfortable being a witness? We would like to interview you.
Yes, I received your email. No, I am not comfortable being a witness as I am the prosecutor. So.
Okay.
I apologize, Mr. Gandalf, but he has a right as a student to deny.
Okay. All right then. I'm going to call Ryan Pavey.
I'm thinking, Mr. Gandalf, Mr. Pavey, you are here. Never mind, clerks, you may continue your time then.
Mr. Pavey, can you hear me?
Yes, I can. Can you hear me?
Yes.
Okay, perfect.
All right. Is the court ready?
Yes.
Okay. Thank you. Mr. Pavey, could you please state your name and title for the record?
Yes, my name is Ryan Pavey, and I am the 2020 to 2021 ASUCI Elections Commissioner.
Could you please explain some of the basic work the Elections Commission has done?
Certainly. The Elections Commission has overseen elections code reform, worked on and finalized election timelines, and is currently managing and working on the spring 21 election timelines. And it's just the spring 21 elections. The elections website is published and candidates are already declaring their candidacy.
Thank you. Can you bring up about these donations? There are allegations made by the prosecution that you donated. Could you explain any part of that?
I do not recall any donations.
Okay. One final question. There's a claim that you did not call the elections. Can you explain when you called the elections?
I would have to go back through emails, but I did call elections.
Right. All right. Thank you, Mr. Pavey. Those are all the questions the defense has. We would turn it to the prosecution if they wish to cross-examine.
Yes, I would. I just have 2 or 3 questions. So do you understand when you donate to a campaign, you have to self-report it?
I do not recall any donations.
Okay. Then why is your name on the evidence?
Once again, I do not recall any donations. I do not recall submitting any donations.
Do you believe the pictures are real?
I do not know.
Okay. What do you have to say about the certification from the tech guy?
I do not know. I was not involved in that.
Okay. Did you call the meeting to call the special election for the deputies?
I would have to review the emails and timelines and personal conversations we've had that were informal. I do not recall.
Okay, that's it.
Thank you. Ms. Gandel, is that all for Mr. Pavey?
Yes.
Excuse him. All right.
The defense,
Mr. Pavey, thank you.
The defense would like to call, or before we call another witness, could we ask how much time we have left?
57 minutes and 20 seconds.
Thank you. We would like to call Derek Littlejohn to the stand.
Thank you.
Mr. Littlejohn, can you please state your name and title for the record?
Can you guys hear me? Okay, my name is Derek Littlejohn. I am the 2020 to 2021 Deputy Elections Commissioner.
Thank you. Could you please state a little bit of the work that the Elections Commission has done?
Well, we've worked on the election timelines. We're currently managing and working on the spring 2021 elections. We've published the elections website and people are already declaring candidacy.
All right. Could you, the prosecution alleges that you were complicit in certain actions. Moving past the obvious political implications, were you aware of the controversy and what were you trying to do about it, or if you did anything?
I wasn't really aware of any controversy or anything against People's Political Party. We don't really talk about political disagreements and things like that. We try to stay impartial because that's our job.
Right. All right. The defense has no further questions.
I have no questions.
Thank you, Iman. Does anybody on the board have any questions while we still have Mr. Littlejohn up? As it is, the board has the right to ask questions as well. Okay. Back to you, Ms. Grandel.
Thank you. We can dismiss the witness. Thank you, Mr. Littlejohn. At this time, the defense is going to move into our substantive arguments. How much time do we have left?
55 minutes and 37 seconds.
Thank you. And would it be possible, if we can divert some of my time if need be, if judges have any questions while I'm speaking, please feel free to interrupt me. Can I allow that?
This board will allow it, yes.
Okay, so please interrupt me. Just start talking. Please don't do the raise hand because I'm in 2 different places. So please just interrupt me. let's begin, if it may please the court. The defense has 4 primary arguments. First, that Pavey unlawfully donated. Second, that he was invited to executive cabinet meetings but didn't show up. Third, that he obstructed legislative referenda. And finally, fourth, that the deputies were being complicit. As we will demonstrate, none of these are founded in the truth. As an overview before going into our defense for each argument, I want to explain that you have to hold to the evidence standard of beyond a reasonable doubt. That is evidence standard used in Yan and for analyzing questions of fact. Today, the prosecution unfortunately misuses, as we explained in our preliminary brief, the Shafty standard, which doesn't actually look at factual questions, it looks at questions of law. It is true that when we're looking at questions of law, for instance, definitions or things like that we look for the preponderance of the evidence. But when analyzing whether somebody actually did something, as was the case in Yan, we look at the standard of evidence beyond a reasonable doubt. Second, I wanted to remind the board of our due process arguments, which I extensively displayed in our lengthy preliminary brief. The prosecution's only answer is making several very confusing arguments about RONR, in which he seemed to deny the existence of Article 1 of the ASUCI bylaws. In effect, the prosecution is asking that we wholly ignore Article 1 of the bylaws, which explicitly states, quote, "The purpose of these bylaws shall be to provide procedures to be used in conducting the business of ASUCI as described in Robert's Rules of Order." Clearly, this is founded in Robert's Rules of Order, admittingly as the lowest tier that is referenced. I completely concur that the Constitution is the highest, and all of our arguments are founded in the Constitution is the highest. But because the Constitution is often very vague, we have to reference Robert's Rules of Order when there is a vague criteria. Now, there can be discussion on how extensively we implement things. In Robert's Rules of Order, for instance, there's a notion of standing. If, a rule's been violated here or there, like the minutes weren't properly kept or something, that can be easily rectified and doesn't require extensive judicial intervention. But when rights are violated, then the judicial board has to be involved. Moreover, after making a quite contradictory argument about procedure, on one hand demanding the Elections Commission have very specific tiny details enumerated, he then attempts to excuse the Senate for their ignoring of RONR virtually. He can amend the bylaws, the Senate can change the rules, but again, it would be a deep perversion of the rule of law to completely ignore the rules, which is what the prosecution seeks in reference to RONR. But let's dive into the substantive case now, which is not exactly connected to RONR. First, on the financial donations. To demonstrate this charge, the prosecution needs to specifically show, beyond a reasonable doubt, that Pavey donated to other ASUCI candidates. First, to be clear, the defense has honestly no idea how this was logged into the system. We were hit with it 15 minutes before the trial. When consulting with my client, we did not exactly know how they got there. There are a million and two ways we could speculate how somebody could get into an account on an AAS machine. They're public. When we were actually, this is before the judicial board was here, but when we were in person, there were public computers all around ASUCI. Again, we're just speculating at this point, though, how that happened. And that's why it was vital, and it's why we included on our list Aaron, which is our IT tech guy, to come and testify on how this process works. In fact, Ivan himself, the prosecution, mentioned that the only way to understand the verification process and the problems with the verification process is by having professional staff here able to testify, and then more importantly, for us able to cross-examine them and extract vital material facts. But because that's not here, we have no way to actually include that. And if we look at prior presidents, the Yan presidents, for instance, electronic information by itself was not sufficient to causally connecting it back to Yan. And I referenced that with metadata, which happened with minutes. In the same case here, we really don't know what happened. It's speculation at best, which clearly neither passes preponderance of the evidence, but more importantly, doesn't even nearly meet the criteria of beyond a reasonable doubt. Moreover, even if this court believes there is evidence beyond a reasonable doubt, which again we argue there's not, the legal analysis on the screenshots can be bifurcated to show they're not sufficient. Screen 01, for instance, is noticed towards Ryan Pavey himself. He didn't actually donate to any candidate. What Ivan did is actually pull up the elections code right now, which while we would argue it's not relevant to that time period, if we do accept it's relevant now, as the prosecution seeks to do, we would have to admit that an exclusionary factor to donations is relationship, i.e. a close family relation. Ryan Pavey is clearly related to himself, so this definition does not sufficiently apply to Ryan Pavey. Screen 02 is completely irrelevant and has to do with a slate Ryan Pavey may or may not have a politically affiliated with, but is not actually related to Ryan Pavey donating to something specifically. There's a completely different question about generalized social relationships, which we will discuss later in our insidious discrimination argument, and actually financially supporting those institutions. These are completely separate arguments, and they should not be misconstrued as the prosecution wants us to do today. In fact, I would argue to a certain extent, because he makes an assumption in his argument, construing them to be one of the same thing, i.e., if there's donation for fund the clubs and it is related to Ryan Pavey, he makes an implicitly discriminatory premise that Ryan Pavey has to be connected to these people, when that is not actually the causal case in this facet. He is completely unrelated. People run unrelated campaigns all the time. So for those two arguments, it's a completely misconception of the statute. The language of the Constitution is meant to prevent bias. Ergo, why it is to donate to an ASUCI candidate. Ryan Pavey is completely within his rights to spend his money for himself. But again, that's only if the board doesn't accept the beyond the reasonable doubt criteria that we've set forward, which I would argue it should, and it's consistent with every single case precedent we've set up until now. Moreover, as Merriam-Webster defines it, if we take a looser definition of donation, it's the act of making a gift. But you can't literally gift it to yourself in the context of ASUCI. So either way...
I'm sorry, Mr. Kim, I have a question, just for clarification. So there's an argument saying that you guys don't know of any donation. This donation is just not a thing. But then you're also arguing if it was a thing, it's not applicable because of the wording of the Constitution. Is that what I'm hearing?
Yes. And we want to be very firm that how that donation appeared, and that's honestly why I was so firm on wanting Aaron to be here. As anyone who's involved in this process knew, I was very adamant on wanting our IT professionals to be here so that we could properly get to the bottom of this. We do not know anything about this donation, how it got there, the electronic process it got there, the verification processes. But yes, that is correct. I wanted to provide the court a separate argument in case they didn't buy Ryan Pavey's testimony. Because at the end of the day, this is really a he said, she said thing at this point. Because it's Ryan saying he doesn't know how that's related, and Ivan having an unrelated screenshot that we have no idea how it got there. As far as we know, you can go on to Google and change items or parameters or things of that sort. And it's why we wanted Aaron to be here to answer those tough questions.
But you do agree that in those screenshots, it does say, Ryan Pavey and then those donations. Is that your understanding as well?
The screenshot physically says it. We're saying that the screenshot's not actually related to Ryan. It might not even be a real screenshot. We don't know.
Okay, thank you.
Yes. And I want to also make firm that there's a reason the system was so inadequate in the prior year, that it was not actually clear who was donating where. There's been numerous legislative items on the verification processes to donations. But again, I think that's a policy question, not a relevant legal question for this board to take up. We should only be looking at if there was sufficient verification mechanisms to, beyond a reasonable doubt, affirm this was Ryan Pavey, which there was not. Moreover, did that answer your question, Judge?
It did, thank you.
Third, I want to reiterate that via Aaron's testimony, he's not indicating that Ryan actually donated to any candidates, if I'm referencing that screenshot. It's indicating there was a submission related to Pavey, not actually to Pavey himself. We needed Aaron here today to establish those material facts, which again isn't possible because of unfortunate administrative criterias. Fourth, as we demonstrated in preliminary, there was not actually an official form to even collect donations to begin with. So it is again confusing to the defense how this hypothetical form exists. Again, and this remains uncontested by the prosecution because it's what Knight explicitly stated. Fifth, as this court's analysis points out in Yan, electronic information is not sufficient to make an inference beyond a reasonable doubt. So if anything, we could simply cite Yan and find here that the evidence cited by the prosecution is not sufficient beyond a reasonable doubt. Sixth, in order to demonstrate beyond a reasonable doubt donations were attributed to Pavey, the prosecution admitted they needed testimony from the administration when they talked about, there was lots of questions, for instance, about Aaron, how vital he was to the system. Again, without that very specific testimony, unfortunately, we don't have much to draw from here. And that's because now maybe the elections commission system can be changed. There's even a process in ASUCI. There's a joint committee on transparency, which can obtain those verification details. The Senate should have done its due process job, gone to that committee, got those verification details, and proved the causal connection. Again, I don't think they would find it. And if they went to that joint committee and went through the process that they were supposed to, as enumerated in the Constitution, as required by Robert's Rules of Order, as required by every single set of orders we have in the bylaws, they would have come to this conclusion. And again, this is why I ask the court to consider how important due process is. It's the very fact that the Senate did not engage in their due process obligations that we are unable to sufficiently prove any connection, which honestly is a travesty to justice in this organization. At the end of the day, there is certainly reasonable doubt that Pavey did not donate to any other candidates or even himself. It's not even clear if this donation screenshot is real or who it can be attributed to. On being invited to executive meetings. To demonstrate this charge, the prosecution will need to show beyond a reasonable doubt that Pavey was both able to and was specifically invited to executive cabinet meetings. The evidence does not stipulate he was invited. The evidence by Malari only indicates he could attend. And in fact, as Malari herself testified when I cross-examined her, none of the business was related to Pavey except his own impeachment. But clearly, you're not going to have Pavey come and testify about his own impeachment unless he specifically asked. Maybe they wanted to do fact-finding. But clearly, in this case, they were not interested in doing fact-finding. And again, we can demonstrate that by how they dealt with the Judicial Board. They didn't want to do fact-finding behind how they dealt with their impeachment. So there's a precedence behind the Executive Board acting without actually doing any fact-finding. So it's clearly applicable that Pavey's not related to any of these executive meetings. The court also held in Yan that it couldn't actually be held against the president if he didn't invite the Senate president or if the Senate president didn't show up to that. I asked Michelle if she ever specifically invited him to attend, and again, the answer was she never did. There was zero business to even discuss. Yes, there was a generalized email out there showing she invited him generically, but there was no business, there was no advisory position for him to take. And because the Constitution uses the term advisory, you'd think there would have to be something he could advise on, but there never was, and they never even made an attempt to portray that. And the president in her testimony indicated they had other handles of business to deal with. Second, Pavey did show to meetings he was explicitly invited to. Now, if Pavey was truly against showing up to meetings, then he wouldn't have been meeting with senators as he did to try to pound out a viable elections code. And as was gone over in preliminary, as the prosecution testified to, there were meetings with Pavey and others trying to get to the bottom of an elections code. Unfortunately, most of the senators, which I wanted to cross-examine for those details, could not be here today, which again, I think counts against the prosecution because their own people who are alleging this in their own fact-finding operations don't want to be part of their actual prosecution. The only way to come to the bottom of this is to investigate and hear the testimony of these people. The prosecution presented a single witness, done a single witness and a few screenshots. Those are not sufficient to the claims that they are making today. Third, the Yan context of evidence, which is the only thing we can go by considering that most of the defendants won't appear here today. The president did, which the defense is happy about, shows that is highly discouraged for non-voting members to actually appear unless there's something to advise on. In fact, there were a few cases, for instance, SAG showed up or other officers showed up, but that's because there was something specific related to their office that they needed to advise the council on. They weren't showing up to every single meeting. So clearly it's not this like normative context like the Senate is, where you have these set criteria of you need to be at the meetings or it's possibly a violation of the bylaws or some other code. The prosecution never actually said about any code that was violated in this regards. So it's not actually an act of negligence on Pavey's behalf, which again if you conjoin all of these situations together, shows that it does not prove beyond a reasonable doubt that Pavey is somehow guilty of not showing up to executive cabinet meetings, and that amounts to negligence. On the right to legislative referenda. To demonstrate this charge, the prosecution would need to show beyond a reasonable doubt that Pavey was attempting to actually obstruct the referenda. None of the evidence actually shows this. Before diving into all of this, I really want you to set the context here because the prosecution seems to misconstrue this. They seem to portray the narrative as it's business as usual. Why Pavey didn't act as usual is beyond us. But that's not actually what happened here. What Pavey did, acting as elections commissioner, was normative and was a call for election under the RO&R ratification procedure, as we outlined in my preliminary brief. I know the court is not interested in going over those exact legal parameters, but more importantly, there was no elections code at the time. Literally, people were in a legal gray zone, which is why so many senators were interested in having this election code, and they were about to pass it. Pavey had set an end criteria. Again, if you go into the minutes, we could get into, if judges have questions on exactly what was the problems with the elections code at the time. There were plenty. There's a myriad of them. Again, I think that's a policy question, not really for the board to get into. But if they want, we can hear those. But more importantly, at the end of the day, it had to do with the fact that the administrators designated a new code on November 30th that made all of this irrelevant. And that's why there seems to be so much inconsistency with dates. Let's go into this argument now. First off, the context of the charge isn't exactly clear. I'm assuming the argument about the summer referendum was simply dropped. And I'm assuming that they accept kind of the legal parameters of this, given that the prosecution's own new constitutional amendments seem to address this. So let's just focus on the fall referendum then. Even if the context is applicable.
Sorry. How do you have the Constitution, the new Constitution? That's not a public document right now.
Right. No, Ivan, you've publicly mentioned this at meetings. I watch AS meetings, and I've heard you guys go over, you need to join this committee. And I know this because you attempted to impeach them earlier, arguing against this. In fact, there's several court cases we can go on. So I'm assuming this is exactly what you're talking about when you tell people in the Senate they need to revise the Constitution to fix those problems.
Well, you said that you knew for sure, and I never have said that. So
that's literally what you said with the Senate. Like, we're picking on items now. But that is exactly what you said. Now, maybe I'm misconstruing and inferring that unless someone. Okay, so if it'll please the court and if it'll please the prosecution more so, I will revise my statement to say it seems that the Senate wishes to amend it, given they created an entire constitutional committee. There's legislation on it. They had 3 different lawsuits based on it, and they've explicitly mentioned to us in those lawsuits when I was on the judicial board that they wanted to amend it. So given that entire lengthy context, I think it's acceptable to say, would the prosecution deny that they want to amend? If they want, I'll give argument. At the end of the day, this has to do with, do you want me to have arguments on the summer referendum? You didn't seem to bring up any arguments about that. I'm assuming there's good context to that. Is the prosecution making a summer referendum argument? No, right?
Can I explain? Like 2 sentences.
You may use your time of cross-examination for it, yes.
The reason we did not present this is because the Elections Commission and Judicial Board at that time did not agree with what UCI policy was telling us. UCI policy was very clear. Judicial Board and Elections Commissioner, however, disagreed with the policy at the time. And it's just, again, we are a department within a department. I have no idea how you can even deny that we have to follow UCI policy. I believe that is in the discovery.
Well, wait, Ivan, I think these are 2 different issues you're discussing here. You're discussing the fall problems that had to do with the November 30th memo.
I'm discussing the summer problems. They give us a statement.
There was no statement by administration. Could you point me to which part of the evidence that that statement exists for the summer referenda?
I would just like to let the clerks know that this is a part of cross-examination time and not about Mr. Gandel's time.
It is not in the folder, but I'm pretty sure I put it in there.
Okay, so just so we don't waste the court's time here, I know obviously we're going to disagree on legal interpretations. We went over that in preliminary. It's why we spent multiple hours in it. if you're not making any summer referendum arguments, which I listened to your arguments, took notes on them, seems like you're focused on the fall, the timeline. I'm just going to focus on fall. Is that all right for the prosecution? Okay, that was what I was asking. All right. Would the judges like me to kind of summarize back at the top, since we had slight...
May you refresh our memory, Mr. Ganda.
Yes. Okay. So basically the context we have here is that there's no elections code for the Elections Commission to actually run an elections on at the time. That includes, as I went over my preliminary brief, important things like how the voting is going to be conducted, how to actually call that election. It's not even clear what suffices to a call. Robert's rules would have like a physical posting place, but that can't happen because of COVID. The university administration does not explicitly have regulations that is about calling elections because the university is not really interested in elections. So there's a legal argument to be had here. But the point is, there was not actually a set way of calling or doing an election. But as I've displayed in the election minutes, there was an attempt to actually rectify that, which was in the process of being solved. The judges can happily go over or ask me questions or ask later witnesses questions on kind of the arguments about these. But again, they weren't actually solved then. And November 30th made all of this irrelevant. So let me continue. Even if the context is applicable, so if you reject that there was no legal gray zone and you agree with the prosecution that everything was completely consistent, the defense remains unsure what the argument specifically is, because as we've submitted in our preliminary, Pavey did actually call elections, which was part of the brief, and he did end up ratifying signatures. There's an argument about what constitutes the ratification of signatures, but may I submit to the court that we agree to the prosecution's definition of ratification, which requires errand, but errand doesn't work on non-work days or submit official documents on certification on non-work days. So clearly we can only look at business days here. We require the administration to actually help us ratify, certify results. There's lots of reasons for that. As the summer referendum problems went up, it had to do with if they're actually members, things like that. For a while, extension students can vote. There's been adjudication based on this. Lots of problems, which is why we needed Aaron, and it's why it has to be working days. Now, maybe a future, as the prosecution went over, a future constitutional referendum should go over, and again, I'm not going to say they are, should go over that definition, but clearly the practical definition that the court should accept is one in which Mr. Pavey could feasibly comply with. Pavey cannot ratify the results without actually knowing the computer system's action of the result. So clearly you have to accept working days, which puts him in the parameters of what happened here. And then third off, there's again, I agree there is a question about calling it, but Mr. Pavey made it very clear to the petitioners and everyone that he was calling the election, and he even issued, I would say, a result that would need ratification by the Senate had they accepted it on the election date. Again, you're putting Mr. Pavey in an impossible circumstance. The prosecution both asked Mr. Pavey to run an elections without an elections code and to release the operating procedures of that election without an elections code. That's simply not possible. Again, even if we were to turn to Robert's Rules of Order, which would have been the lowest governing doc that Mr. Pavey could apply to, Robert's Rules does not allow you to have electronic voting without an amendment to the bylaws, which does not exist at this time, and there was no election procedures to that. Now, maybe there are certain administrative criteria that could have been used, but again, all of that was a work in progress, and none of this was clear at the time. Fourth, the threshold of the elections commissioner only at the time relied on the elections commissioner, not actually the elections commission. Now, if we're going to get very technical here, which the prosecution seems to want to, arguing that the election commission minutes are sufficient to show that there was actually no attempt to call the elections in the first place, which again would disregard the evidence presented that Mr. Pavey did indeed call the elections. I suppose the prosecution's arguing he feasibly couldn't. It's very normal for, and this happened in the past, happened in 2020 when there was only one elections commissioner, which is why the Knights case appeared, that an elections was lawfully held with only a single elections commissioner. And that's happened consistently in the past. Again, we saw that in 2020. We've seen that before. And the reason this happens is because first, the body ratifies it after. And the reason is it can be very hard right after within a 3-day period to suddenly call your entire board together and ratify these results. And that's why Roberts has this procedure. And if the judges are interested in that actual procedural mechanism, please feel free to ask, and I give specifications on that. But I don't think that matters at the end of the day. In fact, the argument the defense would propel is that all of this was negated on November 30th because at the time of the next regularly called meeting by the Elections Commission, all this was irrelevant. So none of the actual contentions made by the prosecution, they either have no standing, they're non-contextual, or they're simply impossible. So you put Mr. Pavey in one of these circumstances that he cannot comply with. Next, let's finally discuss the 3 days margin specifically. If we look at the prior evidence, the Elections Commissioner called the date within the date that could be ratified at the next meeting. But because there was no elections and the administration throughout those processes on November 30th, there was nothing for that body to specifically do. Again, there's a lot of hearkening on confusing terminology between committees and deliberative bodies. I want to simplify the prosecution's argument in that while it might be a deliberative body, the Elections Commission, as is per the Knight standard, that deliberative body can ratify his actions as they've done in the past. And the Constitution actually gives the Election Commissioner extremely broad powers to engage in these actions. It's kind of odd how it's different for recalls versus legislative referenda, but again, we're splitting hairs here when we're talking about the functional actions of the Elections Commission. Now, I would agree with the prosecution that if there was a different finding between the Elections Commission and the Elections Commissioner, that is a problem because the Elections Commission supersedes. But at the end of the day, there was none, so there's not even any standing to hold us on here. Next, let's go to the arguments on the deputies being complicit. To demonstrate this charge, the prosecution would need to show beyond a reasonable doubt that the deputies were actually complicit to some sort of unlawful element by Pavey. But there's absolutely zero evidence submitted by the prosecution actually showing this is causally the case. In fact, as the Election Commission minutes show, it's very much the opposite. Even if you accept all the premises offered by the prosecution, which are false, on the Election Commissioner doing all these things, there's not actually a substantive reason how that causally connects back to the deputy election commissioners. As we outlined in our preliminary brief, this doesn't meet any standard of evidence required to prove this charge, either preponderance or beyond a reasonable doubt. So because there's not even really anything to argue about here, and as I demonstrated with evidence from Derek Littlejohn that they actually were frequently involved, there's no reason to hold this charge. Second, even if you accept the premise that they knew about all these things, that they were aware of this conflict that was happening between Mr. Pavey and the Senate, you should not accept this argument because not only does it not apply to the deputy election commissioners, but at the end of the day, it's not even relevant to the case being made hand of. It simply isn't relevant to them. There's no causal connection. Finally, let's pivot to the defense's argument on insidious discrimination. To prove this as a defense, we must only show that the preponderance of the evidence suggests that the legislation is tainted by discrimination on grounds of political affiliation, as substantiated by the ASUCI Constitution, Article 2, Section 4B. Without even looking at Mr. Pavey's actions, look at the prosecution's own Freudian slip. He referenced Mr. Pavey and others as Republicans. They know who they're whistling, which is why they know what they're doing. This has nothing to do with policy disagreements. This has everything to do with generalized association. Allow me to demonstrate a fact pattern. Is there like a material objection, Ivan, about like if there's an opinion, I'm just going to respectfully.
I was objecting to Republican because you asked for the evidence and I just went over the evidence you asked for. That's all it was.
I know. And that's why we're going to go over right now the problemsome factual history behind the Senate. Clearly not sufficient. Again, I'm going over everything that makes it sufficient. First, on explicit discrimination by the Senate. As I showed you in our preliminary brief, the Senate initiated extremely procedurally unusual action to eliminate Mr. Pavey and those who associated with him from government as an insidious attempt of political revenge. More specifically, unlike every impeachment before it, the Senate did not attempt to offer a fair process either to the election commissioners or the Judicial Board members, both of which were generically affiliated to Friends of Peter, as the prosecution admits. Moreover, what I wanted to point out here, and everyone had a question on why I was asking Michelle Malari about how they handled the judicial board, because we're establishing a fact pattern here related to how they handle impeachments. Now, unfortunately, Mr. Fonseca refused, it's his right, but it's certainly suspicious that he refused to be admitted as a witness on his own procedures for this trial. I asked judges to ask yourself a moment, should we really trust the intentions of someone who doesn't even want to be on the record about why he held this entire hearing? That within itself is suspicious. Not a single senator who supported this act showed up. If we were in the actual House of Representatives or Senate, or however you want to analogize this to, you would have people there who are willing to testify, more than a single person, and more than people who were directly related to the event. Moreover, the Senate has engaged in a systemic campaign to eliminate all traces of political opposition, as evident by R5633, all ASUCI student orientation, conduct, and decency, in which they reviewed no one. They asked no one. They did no fact hearings. They did nothing that the Senate has done since 2016. The fact of the matter here is they were trying to push through legislation to further an explicit political agenda. And again, it is hard to collect factual evidence on this when the own people who started this process won't even testify as to why they started the process. Mr. Fonseca could have come up here and explained to all of you, I started it for X, Y, and Z policy disagreements, but he didn't want to be on the stand and say that under oath. Moreover, let's look at the implicit discrimination by the Senate. The Senate has begun basically a blacklist campaign against any individuals that were even associated with Friends of Peter. Again, Derek Littlejohn testified that he didn't even know about most of these controversies, but purely by affiliation with Pavey, they are being held here. As Deputy Election Commissioner Xana Patton, for instance, who was frequently a swing voter in the prior Senate, was only insidiously targeted in this impeachment effort for merely affiliating. The very structure of the resolution, both in refusing to specify any specific charges and in grouping the entirety of the deputy election commissions into a single category, reeks of discrimination by mere affiliation. The defense intends to prove this and already has by demonstrating to you the fact patterns. I want to bring up one fact pattern that is probably the smoking gun of the defense's arguments. Unfortunately, I was not able to interview Mr. Fonseca on this, whose, again, evidence would have been vital, but Malari did. I would point you to specifically the ASUCI Governing Documents Review Memo submitted by Ms. Ginkle that requires that any enabling documents, activities, or programs be submitted to the administration for review. None of this has been reviewed by the administration. In fact, there are election code amendments that haven't been reviewed. There are bylaw code amendments that haven't been reviewed. And again, I'm going to reiterate this. This reeks of insidious discrimination because on one hand, there's all this legislation that has to be reviewed by this strict, multi-tiered consultation process by the administration, which could take years. It already had, I think now we're approaching the 1-year mark on some of these legislation's reviews. On the other hand, there's legislation like this impeachment effort that has passed out a single attempt at administrative review. So what you're telling essentially everyone who's watching this is, and if the Judicial Board accepts this, is that some people are only allowed to participate in democracy insofar as the administration allows them to. And it is frightening to me that the president of ASUCI, who is included on all these other memos about governing documents, about the prior bylaws, about the elections code, was never consulted in any of this. Her testimony itself is damning to this entire process and shows that this entire agenda has been set up in an attempt to insidiously discriminate. Of course, Mr. Fonseca won't testify to that, but I have no chance to cross-examine him. Again, the court should take, in layman's terms, that is very sketchy. Furthermore, we admit that because none of the prosecution's witnesses will actually appear, including every single one who authored legislation, seconded the legislation, voted on the legislation, everyone who alleged things on the legislation, some of which could be constituted as libel or slanderous, including those against the Judicial Board, except Michelle Malari, would actually testify here today, making any of this difficult to prove, we confess. But Michelle Malari was the smoking gun to it. She showed that none of this was actually relevant to the process, that at the end, there's going to be a different standard held for different people merely because of their political affiliation. The process offered to Yan by the Senate was vastly different. The Senate offered him multiple hearings. They questioned him multiple times. The Senate actually brought him forward and allowed them to hear arguments. Instead, the obvious viewpoint discrimination by both the administration and the Senate here makes it evident to the defense that every attempt was made to destroy the due process rights of the defendants. We cannot tolerate this behavior in any democratic institution. The prosecution attempts to bring up emails as evidence that he did not discriminate. Well, for one, the problem with the emails, as the Judicial Board themselves pointed out and seemed to hint to us at the beginning of this process that they wouldn't be very credible, and I agree they're not very credible, because there's no reason that they actually give us all the emails. It's the same reason all the electronic information is suspect, and it's the same reason why the Yan court didn't take any of the electronic information submitted to be legitimate. There's nothing actually compelling him to offer the emails, which is why testimony is important. Testimony, Your Honors, needs to be upheld as one of the most important fact-finding criteria in any society run off the process of the law. Without cross-examination, without testimony, we can't come to any of this. Finally, what I'm pointing out with Malari's testimony, in summary, is that there's a double standard. Malari passed impeachment efforts almost immediately after the Senate meeting with no attached documentation, no review. The Senate has already gone about amending governing documents with no review. The Senate has already impeached now, and the executive board approved with no review. The Judicial Board needs to be the one to bring sanity back here. The Judicial Board is the ones who need to demand this review happens, and they're the ones who need to hold that this double criteria cannot be held anymore. I want to quickly summarize my arguments before allowing myself to be opened up to questions. I know, and I'm not dropping these arguments, that there were many procedural arguments brought up by the prosecution. I'm happy to answer all of them. I can make them right now. I see everyone is probably a bit tired after 3 hours of arguments and doesn't want to hear me talk about Robert's Rules of Order, but I will happily do so if the judges have any specific questions. In summary, the board ought to use RONR even if the lowest tier because of Article 1 of the bylaws. There are other important governing documents, of course, that are above RONR. In fact, I've always argued, the defense has always contended, that there are other governing documents that superseded RONR. Any governing document supersedes RONR, including Judicial Board precedents, and that's consistent with every case that's been upheld. Second, when analyzing the evidence today, the proper standard is beyond a reasonable doubt as referenced in Yan. And I want to emphasize this for a moment. And when everyone deliberates on this, you need to think to yourself, is there a shadow of doubt that these charges could be untrue? And if that is the case, then you immediately need to find the defendants not guilty. Because at the end of the day, the only way we can protect student rights in the context of AS, especially because a lot of the evidence is hearsay, is by holding a high standard of evidence, which could realistically impact people for the rest of their lives. Third, on financial donations. First, there's absolutely no evidence this is causally connected to Ryan Paby. Maybe it was the court's fault, but again, the defense does not even know how to respond to false screenshots posted about him submitting donations when we're not even allowed to cross-examine the person alleging they're real. Or more importantly, alleging the verification process. It could be Aaron completely believes these are from Ryan Paby, but we don't actually know. Anyone could claim to be Ryan Paby. Ryan Paby could have left something open on the AS computers. There's so many ways to verify this process legitimately, and the prosecution did not take even one of them. They could have gone to the Joint Committee on Transparency. They could have asked Aaron. They could have asked any of the other administrators. They could have even gotten additional information that verified this. They did not take even a single path to verifying it. And for that reason alone, the Judicial Board needs to throw out this entire argument, because at the end of the day, it just shows that the Senate did not do their fact-finding job. And even if the board doesn't accept that argument I made, which is definitely meets beyond the reasonable doubt standard, it's not relevant to Mr. Paby. Paby can't donate to himself. Clearly, that's inferred now by the Elections Code, which talks about familiar lines not being reportable. But second, it's inferred because the definition of a layman's term of donate is you have to give something. But if Mr. Paby is just to himself, then it's not to someone else. There's actually a really easy way, Your Honors, to interpret this statute. Simply, Mr. Fonseca and the prosecution should go to a receipt list and pull up if Mr. Pavey is related to one of those donations. Then they could show, for instance, candidate X, Mr. Pavey donated to. Then absolutely, Mr. Pavey is excluded from this process and should be removed. But that's not actually what he's showing. What he's showing is Mr. Pavey participated in a democratic process which is pursuant to his rights under the Constitution, not that he actually supported anyone. And I do want to point out the slate. I don't even know how the slate is related exactly. I'm sure in perhaps judges could ask questions later to Mr. Fonseca on this. Again, that's by pure affiliation on social grounds, not on actual financial grounds. On the legislative referenda, Mr. Pavey did issue the call in time. And again, this is now getting into a hearsay, he said, she said argument, but the arguments about dates in such reality as the prosecution testified to certify those votes requires approval by Aaron, who only works on work days. And then even when he does, it doesn't guarantee they're immediately ratified. We have to wait. And as Mr. Pavey has testified, we met that timeline. Second, there was no actual elections code, meaning that actually implementing those elections would have been impossible anyway. So one way or another, you are dooming Mr. Pavey to a catch-22. On one hand, he could call the elections, they're probably illegally called, or on the other hand, he could not call the elections, and again, he's at odds with the Constitution. It's a catch-22. One must consider these various factors, ranging from the voting methods to the actual publication of the elections call, when coming to this conclusion. 6, on the deputies being complicit. Again, there is simply no evidence actually offered to this. And I hate to actually make the prosecution's argument for them, but they could have displayed this in a multitude of ways. They could have gone on and pulled testimony from people showing that the deputy election commissioners were actually attempting to obstruct the referenda, that they're engaged in these conversations, things like that. But they didn't even attempt to do that. There wasn't even a semblance of evidence. So even if you believe Mr. Pavey is guilty, he's guilty to the core, the deputy election commissioners have nothing to do with this. And again, I would contend that those deputy election commissioners should be held to the complicity standard, should not even be held to the complicity standard, as was demonstrated by our preliminary brief. And again, at this point, the defense understands that we're beating a dead horse when it comes to discrimination. But the fact that there are legislations still being reviewed for years for a year on end now, and not a single piece by the Senate has, and conjoined with the fact that the current Senate won't testify to this. Clearly, they don't want to be on the record arguing this to this board. They don't want to be on the public explaining themselves why they're held to a different standard, why they're holding themselves to a different standard, should cast some doubt in the minds of this board that this legislation was not put forward in the minds that relieve it of discrimination. Even if that's not sufficient, we look at the fact patterns, and it clearly is. There's targeted attacks on these individuals. As we go back to the complicity standard with Xana Patton, with testimony from Little John, they're being blacklisted. That is just upfront the reason here. No due process, no actual fact finding. It's clear that he hopes that by mere association you find them guilty. For all those reasons, discrimination is clearly evident. For this reason, the court must hold that the defendants are not guilty. I open my time up for questions.
Thank you, Mr. Garandal. Does anyone wish to commence, or would they like me to start? I will start it. We'd actually like to call Mr. Pavey himself forward. So if we may have Mr. Pavey come on camera.
Yes, I'm here, Your Honor.
Awesome. Thank you, Mr. Pavey. Mr. Pavey, I just want to start with a few of the obvious questions the board and I have. Well, first and foremost, why? Because the prosecution and even Michelle, the witness, claims that you are in these emails. Did you never see these emails that you should come to these meetings?
There are essentially automated Zoom emails, but I was never requested to come. Like there wasn't like a specific agenda or anything. If Michelle wanted me there, if she requested personally that I'd be there for a specific thing for every meeting, I would have gone to every single one of them. But I just got the automated email.
Of course. Are there other meetings you attended though that were not directly at you?
There were none. The only meetings that I attended were with the Senate regards to the elections code as discussed in the preliminary.
So, Mr. Pavey, if I'm understanding this all right, because I just want to make sure we have your side very clear, is that these are automated message, and because they are not directly at you, you didn't really see a need to be there. But Mr. Gandil made the argument for you that obviously you kind of do know the rules of the game and everything. So does that mean you consciously knew you didn't have to go to these?
Well, I knew that I wasn't required. I did have an extremely busy fall quarter. I don't recall which dates the meetings were on and my schedules on those dates. But I was aware that I wasn't under any constitutional obligation to attend, and also I would basically have just joined and kind of watched what went on. There wasn't any specific need for me there.
I also have a few more follow-up questions, if you don't mind, Mr. Pavey. So let's say hypothetically you are found guilty. Do you believe that these deputies also fall under the precedents that just because they worked under you that they should be impeached?
No, I don't. I do think that that's a dangerous precedent. I don't believe that the deputies are guilty of anything. And therefore, I don't believe like that. I don't believe that if I'm tossed out, or not tossed out, but found guilty.
I understand. Yes.
Yeah, yeah, I don't believe so.
A few more things. So if going off of this, obviously a lot of the prosecution's arguments towards you are obviously that they could have done something, that it is in the Constitution that they could have done something. In your position of power, were you guys ever led to believe that you understand your powers or your rules per se, doing your job? Were you ever made to uphold those at any moment?
Well, I wouldn't say power is the right word. I'm not like their boss. We're a team. The purpose of me is to lead, not really to be their boss and have power over them. So there wasn't really a power dynamic in there.
Understood. I'll be opening it up to the rest of the board now. Go for it, Catherine.
And Mr. Pavey, for your understanding, how do you submit the donation to the website? Like, how would your name have appeared?
I do not recall the specifics. I know that submitting everything, I believe, is due. I know for this year's election cycle, it is everything regarding you applying regarding your application to be a candidate is due at the same time. I don't recall the specifics or which forms were filled out.
Mr. Pavey, in your opinion, why do you truly believe that the prosecution is coming for you specifically? Because it appears that Mr. Gandil's entire argument as your representative is very much that this is kind of discriminatory. So I really want to know your personal stance on why do you believe that they are coming for you?
Well, it goes back to me being a senator last year. We had some disagreements, Ivan and I, and the other dissenting senators on lots of legislations. That's where I believe that it started. And it really goes back to the summer. During the first meeting of the Senate, which was technically supposed to be a training meeting, I was impeached. There was an impeachment attempt. I was a legislation submitted to impeach me and all of the deputy commissioners. So essentially, that's kind of how I was welcomed into being the elections commissioner, was just with an impeachment. So that's why I feel discriminated against. I feel like they've been out for me since basically the beginning of my term as the elections commissioner.
Thank you, Mr. Pavey.
Of course.
Can I ask a question to justices?
Sure, Mr. Seca.
Can I just do? I am basically just watching right now. I can't. There's nothing I can say or do, right?
But essentially, yeah.
Okay.
But yep.
And I will have time to respond later, or how will that work?
You get a rebuttal.
Okay.
Yeah, you'll receive rebuttal time. Yes, thank you.
All right. Well, then I'd like to ask a question. Did you have any formal vote when it came to determining the time for the special election after the impeachment of the justices?
A formal vote, yes, we all agreed that it was by unanimous consent. There wasn't like a tally. It was simply in Robert's Rules of Orders is how we we ran our meetings, and if everybody agrees, you can have it voted unanimous consent.
Mr. Peavy, we saw the meeting minutes for all the commission meetings. I just want to make sure, are those like up to date, and those are all the meetings for every meeting you have? Were there any informal meetings of the commission that there weren't minutes kept for some reason?
Any informal stuff may have been over a Facebook Messenger chat. We have a group chat like most every office in ASUCI does. But all official business and all official meetings pertaining to everything are on the minutes, and they are up to date.
And were these random, sporadic? Because I didn't notice any consistency to it. So was this whenever you wanted to call a meeting, or was this weekly, monthly?
We had a general time of the day that when we would have meetings. First it was 10 p.m. and then it went to 7 p.m. because of people's extracurricular obligations. But it was whenever a pressing matter came up. So let's say when the Senate when there was a need for an elections code, I said, hey, everyone, we need to meet. What's a good time that we can meet? And then that's when we would have a code. There wasn't like a scheduled meeting. This was when there was pressing matters that were pertinent to us.
Okay, and am I correct when I say that at the time when the petition met the threshold of signatures, there was no elections code at that time?
There was no elections code at that time.
Okay, thank you, Mr. Peavy.
Of course.
So we see that you didn't have a formal meeting regarding calling the a special election. Despite like you may not remembering who you may have spoken to, do you remember having some sort of informal conversation with anyone else regarding calling that, or was it just you that called that?
I don't know the exact time frame, but the deputy commissioners were aware, and I made sure. I believe that was in our informal Facebook chat. But I did act within my authority.
Your Honor, if we could point you to the November 2nd meeting minutes. Obviously, they weren't done exactly like how Roberts wants in a resolution format, which is normal for non-legislative bodies. They did work on that. As I said, it was a ratification process pursuant to Roberts because they didn't know how to handle. So yeah, it seems a little informal, but that's because the situation was gray.
Thank you, Mr. Ganda.
Mr. Peavy, to your understanding, does Aaron need to validate the signatures, or is it up to the commission to validate those signatures?
There's a validation process for both, and they were validated by us, and we saw that it reached the threshold, and that was sent to Aaron, and then they did validate that. That's when we did send out our correspondence on the special election.
So do you have to call the election after Aaron validates it or after you validate them?
It's after Aaron. It's after the administration gives it the go-ahead.
Okay, thank you.
Yes.
Mr. Baby, to your knowledge, have you ever heard of or seen of these type of donations faked beforehand? Is this something new?
I'm not familiar with any sort of donation process. I can see how that could be faked, but then again, I have nowhere near the level of expertise that Aaron Eccles does. I just simply know, that's not really my area of expertise, but I can see that there is a possibility that they could.
Yeah, this image is quite convincing, but if it's true that this is fake, then we very much understand many of your claims going forward. Mr. Pavey, so is there ever any communication with not exactly the Senate? Like, is there any communication with higher ups? Is there any communication in moving forward? I know Aaron is one. Is there anyone else that you're ever in communication with about anything?
Yeah, I'm in communication with Stephanie, the executive director. I'm actually in a back and forth with her right now about timelines for the coming election, and I have been all year.
All year? Awesome. All right,
Yes.
thank you. Thank you. Is I know Mr. Gandalf did make the claim that obviously Senate things should be going up to be reviewed. So I was just curious if the Elections Commission also has a communication with someone of a higher up.
Okay, yes, we do. We have communication with any higher up.
Mr. Gandalf made this case in the preliminary, and he brought it again once again today that COVID-19 really threw a wrench into the elections and really threw you in for a really rough situation. To my understanding, considering there was nothing in place for you to really go to about it all, for a lack of a better term, you were kind of just left in the dust for this whole job. And you've kind of just been left in this tough situation where because of COVID-19, you couldn't conduct your job properly. That is an argument Mr. Gandalf made in the preliminaries, and he kind of hinted at again today. So would you say that due to COVID-19 that you were in a different situation and you didn't really know how to proceed forward with any of this?
Yeah, I would say that is accurate. Essentially, there would be no in-person aspect of the elections. It would be something never done before. And I felt that something that's never been done before can't really be done when there's no backbone like an elections code.
And were you working with anyone that would get this going, make it go forward?
Yes, this would all be with Aaron Eccles.
With Aaron Eccles. And you, Mr. Pavey, do claim that you were in communication with Mr. Eccles the entire time.
Yes.
And all that. Okay. Thank you, Mr. Pavey. That is all I personally have for Mr. Pavey. If anyone on the board has anything for Mr. Pavey. No? Okay. Thank you, Mr. Pavey. Oh, never mind.
Oh,
I take it
sorry.
back.
Well, sorry. Just I just want to like, is there anything you would want to, you know what's happening here today? Is there anything you would like the board to take into consideration that's obviously relevant to this hearing? That would kind of explain any of the arguments that you heard today, because there's a lot being thrown at you, so I want to give you the chance. Is there something, you would like to explain on?
Chemo explained pretty much my perspective. I agree with the defense on pretty much everything. Yes.
Okay. Thank you.
Thank you, Mr. Pavey. May I please call Mr. Littlejohn? I just have a few questions, considering, to my knowledge, he's the only deputy present, and he was a witness. Hello, Mr. Littlejohn.
I believe Mr. Palafox. I believe all the deputies are present, actually.
Wonderful. Oh, thank you, Mr. Gandalf. So we'll start with Mr. Littlejohn, just because you were the witness that was first called. Mr. Littlejohn, this is obviously a very strange situation to be in. To your knowledge, were you ever not doing your job?
No.
Do you feel the entire time that you were upholding your office to the best of all of your capabilities?
Yeah, I was there prepared for anything that was sent to me.
Were you ever aware of Mr. Pavey not attending meetings that it was implied that he should go to? Were you ever aware that he wasn't going to these?
No.
No. Do you, Mr. Littlejohn, feel targeted against, or do you feel like you're just a casualty of being in the same commission?
I just feel like I don't know. I don't know what I did wrong.
Okay. Yeah. Understandable. Thank you, Mr. Littlejohn.
All right. So if I can ask, what is your opinion of Ryan Pavey as your elections commissioner?
That is for you, Mr. Littlejohn. Who we saw that
for
you
Littlejohn.
Yeah.
Right. I never saw a problem with it.
All right. And how much do you recall when it comes to any discussion or vote on the special election?
Oh, I cannot recall. That was a few months ago.
All right.
Mr. Littlejohn, do you remember or can you recall whether you were notified of you guys have to call a special election at all?
I cannot recall that either.
Mr. Littlejohn, so if you or any of the other deputy commissioners saw Mr. Pavey act in such a way that you believed went against the ASUCI governing documents or just the student government in general, would you or do you believe there was some way you could stand up to him?
What was that? Sorry, that was worded a bit weird.
All right, let me clarify. So the defense states that the election commissioners could have done more. They could have.
Sorry, my dog.
Right. Essentially, the defense states the election commissioners could have done more. They could have, if they saw Ryan Pavey not or actively not scheduling the special election or trying to, that you and the other election deputy commissioners could have stood up. You could have done something. You could have made a stand. For I guess what I would like to ask two questions is, do you believe that there is anything you or any of the other deputy commissioners could in your power do to stand up to Mr. Pavey if you saw him doing something that was unconstitutional or just not fulfilling his duties? And then the second part of my question is, if you were in that situation, is would you stand up to him?
For the first one, absolutely. I believe I would be able to speak to him directly. And after speaking to him directly multiple times and him just brushing me off, I'd go farther up the ASUCI chain of command. And then I would absolutely bring it up if I saw anything weird going on.
For Mr. Littlejohn, to your knowledge, what is an elections commissioner supposed to be doing? What is your role?
We just make sure the elections go smoothly. And we're there as soon as we're needed.
All right.
Mr. Littlejohn, did you have any affiliation with ASUCI before becoming a deputy commissioner?
Yes, I was actually a senator last year. I was appointed in mid-school year.
Thank you, Mr. Littlejohn.
And just to clarify, all your duties that you said, like when you're told to do, that all comes from Mr. Pavey. Is that correct?
Yes, absolutely.
Okay.
Mr. Littlejohn, obviously, Mr. Gando is very much making the claim that the prosecution is being discriminatory against you all. Do you affiliate with this slate that's being referred to as Friends of Peter or this other slate? Are you a part of this group that's supposedly being targeted?
Not that I know of, at least. I may know people that are supposed to be part of it, but I hope I'm not affiliated with them.
All right. Thank you, Mr. Littlejohn. Thank you. Does anyone else of the board have anything else for Mr. Littlejohn? Thank you, Mr. Littlejohn. You can step away now. I appreciate it.
I just want to ask if it's okay with Mr. Serrano and Mr. Gandel if we can ask, not Mr. Littlejohn, but the other deputy commissioners some questions if they are willing.
Seeing that they are part of the defense, I would say it is okay. But if Mr. Gando is also fine as his representative, if they can be asked questions.
Of course, the defense is open to everyone being questioned to secure the confidence of this board.
Thank you, Mr. Gando. Gio, you're free to call upon any of them.
Sure. I just call
all deputies.
Yeah, Palafox. Is Palafox here? I don't want to give a title without knowing. Mr. Palafox.
Hi, everyone. I apologize for showing up late. I was gone for majority of the meeting, so please be patient with me if there's any gaps that I'm not too familiar with.
No, we understand. Thank you.
Thank you.
I just wanted just a quick question on, can you just, synopsis describe, your duties as a commission and kind of what was your experience like in the commission under Mr. Pavey?
Well, to be honest, I wanted to kind of, if I may, address a question you asked earlier to Little John about how it was to work under Pavey. And to be honest, he and I guess, in a personal level outside of student government, we don't really agree on a lot of things. And I think there's value in that. So there was this question of, would you be afraid to speak out against it? And I had experience working at ASUCI for, this is my third year, actually. I was a senator last year. And then I was an internal SAG my second year. And overall, I would say that the experience was pleasant. We worked through the elections code, and my job mainly was to kind of facilitate any discussion that I felt was needed, especially if I had input that I could have contributed. But overall, I found it to be pleasant, and there was never a moment where I felt I didn't have a voice per se, if that was a question that was being asked earlier. But overall, I find it to be pleasant.
Mr. Palafox, same as to Mr. Littlejohn. Do you personally feel like you're being targeted against, or do you feel like you're just a casualty, again, lack of a better word, of just being grouped together with Mr. Pavey?
To be completely honest, I think it's a targeted move, and I will provide several reasons for that. First, even if I was a Republican, I'm not. I believe I heard I came in a little bit late, so I don't know if that was an argument that was made, but I am not. And even if I was, I don't see how that would be relevant. And then two, I didn't run with any slate, right? So last year in Senate, I voted as I saw fit with my constituents. And this year, I was kind of surprised. I had no knowledge of basically anything of like the drama going on. So when I found out that I was in the running to be impeached, I was taken aback because to my knowledge, everything was going smoothly. So I wasn't sure where this came from. And I do feel that it was discriminatory by association with Ryan. So I think, yeah, that's what I would say.
Thank you, Mr. Palafox. Am I saying your name correctly? I don't want to offend you.
Yes, Palafox.
Wonderful, thank you.
As it pertains to the special election, that's pretty relevant to today's case. Is there any information you can give us? Were you aware that you guys needed to call a special election? And if you were, what was that process like? How did you guys start working towards the election, and if at all?
Yes, so I was aware, but I really was there. So my role, essentially, like I mentioned earlier, was typically, if something needed to be done and then it was asked of me, I would provide input. But aside from that, I don't really recall any specifics. So yeah.
So you were aware that a special election needed to be called, but there was no work towards it?
No, I was aware that there was one. Yeah.
Okay.
Anyone else wish to ask Mr. Palafox any questions? Wonderful. Thank you, Mr. Palafox. Gio, would you like to call any more of the defense forward?
Honestly, it's up to everybody else.
May I ask the clerks
they
how
want
much
to.
time we have allotted to this?
4 minutes and 50 seconds left.
4 minutes, 50 seconds. Understood. I guess we'll just turn to Mr. Gandalf now, just to make things more smoothly. Mr. Gandalf, considering you were saying that it is very, in your own words, sketch that Mr. Fonseca wasn't willing to be a witness. It seemed a little strange to the board and I that when Mr. Pavey was first asked questions, he very strictly knew to keep saying that he does not recall. Was this practiced, Mr. Gandol, or?
Well, I mean, when I consulted with Pavey, I asked him a very front-word question because I'd never seen this evidence before, 15 minutes. And I asked him, like, did you do this? And he said no. And I said, okay, well, then tell the board the truth and tell them you didn't submit it. And just be forward with them. Because the problem here is it's very easy for someone who hasn't been, as you know, properly trained on the law to get caught up in these things. So obviously, I asked Pavey, and then I told him, well, if you didn't do it, then tell the board that. And then he's like, well, how do I say that? They're going to just say I'm lying. And I said, just say it, and we'll explain to the board everything. Obviously, I didn't have an extended period of time to coach him. I got this like 15 minutes beforehand. So, yeah.
Understood, Mr. Gandol. I just wanted to clarify that in case it did seem quote unquote sketched to individuals.
No, and I understand maybe if it sounded over. I think what you're trying to get is it sounded overtly legalistic for someone not normally in the legal process. But the reason I wanted him to say that specifically is it very specifically denies the allegation. What I don't want is a vague answer that sounds like you're trying to avoid the question. I want it to be very clear that we did not donate. Because especially with very skilled cross-examiners, people get tripped up and then, it becomes obfuscated. And I want to avoid that, especially because of the second legal argument I was making. I wanted to avoid obfuscation.
Yes, Catherine, go for it.
So as I asked Mr. Pavey, he wasn't sure how his name got onto the list of donations. Mr. Gandol, do you know the process of putting one's name onto the website?
It has changed in the past. I know from 2016 it has, Ivan, and I'll explain right now why it's changed. In 2016, originally, you did not need verification to submit a donation form. The problem in that election was extension students, i.e. myself, that's Gandol Spring, had donated, and there was no way to handle that. In 2018, I think during the Grineal administration, there's a question on outside donors coming in and submitting forms, because clearly outside donors could influence on this. As of the most recent process, it was, to be very frank, everywhere. Because of the Knight decision, there was no, and this was what I was trying to enunciate, there was no actual way to formally go about doing this. Now, how I assume it would, and what I wanted to ask Aaron, because I did not partake in that process, is I would assume you would go into your account and you would submit it that way. And that was the new verification process, which prohibited extension students and prohibited undergraduates, or prohibited undergrads who were not allowed to, and prohibited grad students. I don't know how the process was formally set up and the verification mechanisms used for the process. I would need, again, I wanted to cross-examine Aaron on that because I had a bunch of questions myself. But again, I wasn't able to. So I don't know. I can only tell you what my experience was. And that was my experience with it. It's changed a lot. At one point in 2016, it was like the wild, wild west of donations. Luckily, it's been reined in a little bit. But I'll be frank, after Knight, I know from my view, I was working with Michelle Bundes, who's Chief Justice at the time. We had the same question: how were donations working? One of the ways was we emailed. We told people they could email their donations in if they wanted to portray them. There's a second argument. Here's the two arguments. First off, how do you actually portray donations? Because the elections code is usually needed to properly portray them. The Constitution does state about donations. So there was some implied, even without the elections code, you should have donations. We didn't know how to actually have that system because Robert's Rules of Order has a very convoluted system for submitting finances. So essentially what the board decided is you could either go through the website or you could go through email. And either of those would suffice. Or the third way was you could go through suit.
Sorry.
Okay. I'll very quickly finish.
You may finish your sentence, Mr. Gandol, and then that's all of our time.
Okay. Yeah, so there were 3 different ways I know off the top of my head of submitting these finances. And I have no idea. I've never seen that one when I was Chief Justice, given I had to write like 10 case opinions. So I have no idea. It could have got lost in the system. I have no idea how it got there.
Thank you, Mr. Gandel. Considering that is all of our time, we'll be moving forward from this section. We shall be stepping into the 10-minute rebuttal from the prosecution. Ivan, this is your time to bring up any final things you have, rebuttals to what you just saw. And then after all that, we will move into a 10-minute closing statement.
Yes. So first of all, the reason many of the people who were requested, by the way, a lot of people were requested by the defense for testimonies, was A, you notify them 48 hours beforehand. That's not significant time, especially given around this time, week 9. B, it's a Friday night. I'm pretty sure anyone would rather be somewhere else on a Friday night. And C, there was a real fear that some did express to me about being taken out of context. Chemo literally did this himself today when I said, the only time I said a Republican was because when I was explaining how the results of my email search. That was the only time I ever mentioned a Republican, if you paid attention. He then alleged that I dog whistled Republicans several times and alleged that I said Republicans several times. That didn't happen. Most senators, most people in this government are fully aware that that's something that he is known to do, and they just didn't want to be part of it. Second of all, this idea about administrative review being selective and being discriminatory, it's not, let me put it this way. Before the way they will review legislation or review stuff, they will literally notify what if there was a problem with the legislation, and more often than not, most legislations didn't have a problem, they would notify the Senate President or notify the Senate. And after the legislation was passed, they would more than often than not, administration would notify that this can't be done for whatever reason. So that happened last year with the Infrastructure Act that was passed by last year's Senate. In an act of, I guess, deciding that the rules don't apply to them, they passed a legislation, and let me pull it up. The 2020 Democracy First Act, which is B5508. And literally, this is one of the first lines, where ASUCI bureaucrats have declared that certain legislations cannot be implemented because of their personal opinions and interpretation of Senate procedures. But the bureaucrats that they are referring to is administration. They are literally saying administration cannot decide what's not. They literally passed a legislation to fight administration, so administration can't tell them what they can do, what they cannot do. That's the whole reason they passed the legislation. So they were being told that these things did have to go through review. They were, in fact, being told that. That's a full fact. They didn't like it, so they passed this legislation. There is a review process. The Infrastructure Acts, along with all those stuff that the memos are about, they were always going through the review process. As soon as they were passed, they began a more extensive review process. And they, specifically with the engineering one, they passed so many legislations relevant to this that they just kept adding them on. That's why that memo specifically on the Infrastructure Act is as many pages as it is, because they were going through the administrative review. That was a process, and they were eventually determined not to be able to be implemented because of UCI policy conflicts. That is another fact. So this administrative review has never been used discriminatory. It has always been applied to everything we've ever done. However, the only thing that really changed was last year's Senate chose to fully ignore administration. Last year's Judicial Board is now impeached, literally tried to overrule administration as well. That is really the only thing that has changed. Everything else, all legislations that have been passed, literally go through review. As Senate President, I get the administration's review process. I get the review process. I get those emails because the last year's Senate was so neglectful on following the administration's procedures. They are more harder on us now than ever before. They are literally hawking on us now. Literally we basically run through any bylaw amendments that we want through them first for the most part. So that's the administrative review that has not been applicated. It was not discriminatory. There was this whole thing about the way we report financial statements. The elections code is very clear. You self-report. If you go to the elections website right now and click ASUCI, well, no, it's under documents. elections.uci.edu, go to documents, ASUCI candidate financial statement form. It clearly says this, and this is the process. The form can only be accessed by declared candidates. This form is currently closed for submissions. You have to be a declared candidate. The way you do it is literally by logging in with UCI Net ID, which for us, since we're university employees, requires dual. We have to do the mobile dual. That is, I don't know why Aaron couldn't show up. I'm assuming it's because this thing's after 5. But as he indicated to me, anything that you guys ask for, he will provide if you guys order him to do it. Yes. So the only person who can actively put that's the money they donated was Ryan himself, and he had to log into UCI Net ID, go through the dual process. That was the process that was laid out. Aaron, the neutral guy, the tech guy, literally did, as I provided the email, did certify that yes, that's what is written on there, and these screenshots are what's there. That's, of course, the defense will literally allege that anything I show them is fake or illegitimate. In regards to the deputies, well, first of all, the election, I have to address the elections code. You guys threw this out, the whole perjury charge, but that's, I can't really say too much on that because you guys indicate you guys don't want that, but that's was entirely relevant to perjury. Like I said before, there was an elections code that was agreed upon. Several senators were there. I was there, and they just, Ryan Pavey said, yes, I agree to this. I think a week later said, I don't agree to this anymore, and I never agreed to it. That is what happened. Yes. So there's that. The Elections Commission deputies being neglectful on their jobs. Daniel Palafox literally said himself, he said, I was aware, and we asked him again, he said, I wasn't aware. Or I wasn't, something like that. It was very clear he was aware, and the deputies were aware, they just didn't really care. There is no discriminatory things. Everything that the defense has really argued is just, really what it is, well, these people committed this thing, so I'm going to say political discrimination on this, just because it is kind of relevant to everything, but I never said those. Sorry, give me 1 minute. I have dry mouth. Yes. Let me go over my notes real quick. How much time do I have left?
2 minutes and 35 seconds.
Yes. So it's quite clear, no matter how you frame it, they didn't do their job of calling a special election for 3 days. They didn't even defend that, actually. They just, yeah, no, they had no explanation why they didn't do it. Ryan tried to do it, but didn't do it. The commission had no say in it. And they even themselves couldn't really say anything about it. So that is on its own very interesting. The reason I didn't allow myself to be testifying is that's weird. I don't know. Like, I'm the prosecutor. That seems like the most informal, dumbest thing I've ever heard of, being called to be a witness to begin with. I don't know why I would. Yeah, no, that was just weird. Hold on. Oh, well, there was this allegation about, it was mentioned, but then it was kind of thrown away by Chemo's own statements. A donation is very clear what it is defined as in the elections code. It is any donation to a campaign outside of a family member. Unless Ryan is his own brother, it is very clear that that was in fact a donation made. This idea of needing, oh, that's another thing. The defense, Ryan Pavey himself, alleged that an election in a pandemic has ever been done. That's a lie. The general election was done in the pandemic. The general election was held three weeks ago to this year after the pandemic was declared. So we did see a process. We did have an election during COVID, and it was proven and it did work. It happened. He alleged that it didn't happen right there. Unless he denied an election occurred last year, that's clearly that the Ryan Pavey lied to you all. And he's lied about several things as well. How much time do I have left?
29 seconds.
Yes, and that's really what this is about. There were several things that were just denying the concept. Several of the defense's arguments were just denying the concept of reality itself. The donation was in fact made. You need your UCI identity to log in. You need to go to dual process, and only you can be the one to make it. Aaron certified that the donation was legitimate. The alleged that the election there had never been an election in a pandemic before, and there was. He's lied to you. You guys were there.
Thank you, Ivan. We very much appreciate your time. Mr. Gando, you have a 10-minute rebuttal as well, and then we will move into our closing statements.
Was that 10 or 5?
This was 10 minutes. You get
Okay.
10 minutes as well.
Okay. And when I say I presented my argument just before my time starts, if any judges want to interrupt me while I'm speaking, please do so. Yes, I will allow my time for that. It allows the board to clarify what I am arguing. All right, let's just start this from the top, and I'll take it on the order that Mr. Fonseca presented it. First off, on witnesses, it is not sufficient to argue that just because there's this scary undergrad kid, that your statements be taken out of context is sufficient to not show up, especially when you are a direct material witness relevant to the actual hearing. Imagine what the defendants have been dragged through. Imagine if the defendants took that same claim, but that's not what's supposed to happen. People are supposed to come forward with the actual facts and truth. Second, deny the argument that he wasn't a witness because it's dumb. Mr. Fonseca is not a nobody. He's not like some random appointed position to this job. He's the Senate president. So of course he's going to be material in this, because how are we supposed to question the process if we don't question the Senate president? It's just a ridiculous argument. Second, moving on to administrative review being discriminatory. I'm not arguing that I disagree with the process. Now, at the time when I was on judicial board, yes, I disagreed with part of the process, but clearly that's not the case in the status quo. We're talking about what we are arguing now, not then. And I'm arguing that the administration is not fairly reviewing right now, but more so that Mr. Fonseca and others haven't fairly gone through the review process as other pieces of legislation have. Now, maybe there's like this pseudo process, but it's not the same process. And so you can't apply two different standards to people. The administration has never attempted to apply this review to the Senate, as it's already had. And this is the exact reason why I wanted to question Mr. Fonseca on this, because he's not actually telling the full truth. I know Mr. Fonseca and I will go back and forth, claiming each other are liars, but at the end of it, if he was telling the truth, then the new edited bylaws and the new, by the way, they edited the elections code again, wouldn't have been implemented now. It took months prior for the elections code review to happen. So clearly that's not true. Now, I unlike Mr. Fonseca, I'm not going to go as far as claiming he's a liar, but I think it's not consistent with his statements. Third, with the finances election website, this is extremely important to contextualize. First, it ignores the entire context of what the Knight case was actually happening with. So let's look at the Knight. If we look at the actual Knight case, a big part of it was that it occurred like halfway through the election process, right? So at the beginning of it, you could have self-reported in some ways. At the end of it, you could have reported in other ways. To be honest, we don't really know because we don't know any of the specifics, because we weren't Aaron wasn't able to testify, to be just very blunt with it. Moreover, things have been worked on with Pavey to make the system better along with Aaron. I will say that because there's an elections code now, we can have a consistent way to report to the website. Back with the Knight case and the shenanigans that opened with it, it wasn't clear, Your Honors, that this was a consistent process. So clearly there's some speculation, in fact, whether this even was Pavey. Moreover, going on to the legislative referendum, 3 days, we did do that actually. Not only did we provide evidence, now it's on working days because we needed Aaron, as he himself testified to. Yes, there's some discrepancy on what actually constitute days, but clearly, as I indicated, you are putting Mr. Pavey in an impossibility. You're asking him to ratify things he physically doesn't have the electronic infrastructure to go into the computer and look and ratify and verify these results. So clearly you needed Aaron in this, as Mr. Pavey himself testified. That has been the process since ASUCI has been conceived. And the administrative staff have always had these processes. Moreover, he's claiming Mr. Pavey lied because there wasn't an election during COVID. The 2018 election might have happened during COVID, but the call to election, which is what this discussion is about, did not happen during COVID. We were still in person. Everything was still functioning. So yes, the call still happened. And what the Judicial Board reasoned at the time, maybe it was right or maybe it was wrong, is that if at the time prior to COVID, those procedures could still sort of stay in place. I agree that the Knights case had problems with it. You had a Judicial Board with varying opinions. In fact, there's actually a footnote on that. But the law is the law nonetheless. And the law clearly stipulated that there wasn't at the time. So, it's just going to be the way it is with the fact that there's no way to truly track back to what was happening during the Knight case. And this is a problem that actually still plagues the current elections code, which is why Mr. Pavey was so worried about it. He was worried because the same elections code has the same legal flaws as the one overturned in Knight. So it's very plausible that this court could have the same lawsuit on their footsteps once the elections actually begin, and we'd be stuck in the same fiasco as before. Moreover, let's go back onto the actual specific case we've made. There's been arguments that there was no sufficient evidence actually pointed out with discrimination. I'm just going to point them out very quickly. With explicit discrimination, I cited R5633, which was clearly targeted. There was actually no counter-argument made by the prosecution on that. And it clearly sought to demonize and institutionalize the expulsion of certain members, and it was based on a clear hostility, and there was no counter-argument to that, so the Judicial Board should just take it as it is. There was no arguments made against guilt by affiliation, and there was only an argument made that they're still following this administrative review process. But then ask yourself, why isn't the administrative review process fully finished for other pieces of legislation, but have for these pieces of legislation? And more so, why has it happened so quickly? It seems like there are favorites being picked here, and those favorites are arbitrary decisions being made by the Senate president, which I wish I could have questioned, but I wasn't able to. Moreover, if we look at the actual argumentation we're making, most of it goes ignored. Let's look very briefly at the executive cabinet meetings. There was no contention made that Mr. Pavey actually had to be there. Mr. Fonseca had time during rebuttals to actually make an argument that, yes, Mr. Pavey was needed and there was business present. That argument was not made. So at this point, we should just consider that argument with the prosecution. Consider it dropped in essence. Let's go back onto the specific arguments of financial donations. So Mr. Fonseca goes very specifically into the definition of donation. So let's ignore for a moment that everything I've said, the multitude of ways that this could have been frauded, the multitude of testimony we've received that Mr. Pavey did not donate. Let's just ignore that for a second and pretend he did. Even if he did, it's a complete misconception of the statute. Mr. Fonseca, the prosecution, alleges that it does apply to him under the current elections code, which again is absurd because how can you apply a code to Mr. Pavey that was not in effect at the moment? That makes no sense. But even if you do apply that same code, he is directly related to himself. That's the only requirement, objective requirement in the statute. It's not a requirement of a separate person's. So in essence, it is himself. And there's good reason, right? Why would you ever report about yourself? We're interested about external campaign finance donations. That's why the law is set up in the way it is. It has nothing to do with yourself. So because of that, the board at the end of the day shouldn't take his argument into consideration. Not only because very specifically and tautologically we're correct, but because it doesn't make any sense to have a statute relating to yourself, which is not only completely unenforceable, but makes no sense as the diction of it goes. Again, I wanted Aaron to be here to confirm these things, but that's not possible. I think there would have been a lot of good done by cross-examination. But again, I think there would have been a lot of good done if the majority of the prosecution simply showed up and decided to testify as to why they voted to impeach Mr. Pavey. There's clearly other implications in here, especially on perjury. Obviously, that was a charge thrown out. But if anything, the board should take that as clear evidence that the fact-finding was not done on behalf of the Senate in this behalf. Thus, in order to actually demonstrate beyond a reasonable doubt these donations were attributed to Pavey, they would need to both prove that he actually causally did it, and second, that it actually directly relates to him as a result of the statute. Moving on to the deputies being complicit. There wasn't really any rebuttal made onto this, and I think there were some very clear arguments made both in additional testimony the Judicial Board took and testimony made earlier with Mr. Littlejohn, that they were doing their jobs and they were doing their jobs accurately and actively. And because of that, they weren't being complicit. Unless the Judicial Board wants to establish quite an arbitrary standard of requiring we identify every meeting someone's supposed to be showing up to and then record those and then make a decision off it, then we can't hold them to that standard. But moreover, we actually have a position in ASUCI which does so. And by the way, I asked him to appear as a witness today, but again, not. In fact, I asked everyone in the SAG. I asked SAG and I asked the Mr. Wiley Wilson, who works for the SAG, to keep track of these attendance records to show. And unfortunately, he didn't, so he couldn't answer these questions either. At the end of the day, this is a real problem to the defense because there's some implied argument by the prosecution that it's on our burden to prove these things. You should penalize the prosecution for not having these people show up and not having these people make their arguments about attendance records and the importance of those attendance records and how those attendance records apply. For these reasons,
Oh yeah, the 10 minutes.
Thank you. For these reasons, we ask that the court find the defendants not guilty.
Thank you, Mr. Gandal. That concludes our 10 minutes of rebuttal time. Gio, I see you've turned on your mic.
Yes, Mr. Serrano, I would just like to motion to extend the meeting for about 15 minutes to allow for Judicial Board questions of defendants pursuant to Mr. Palafox's testimony. I think it's kind of important for the board to hear more information from the other deputy commissioners if it's fine with them. So I would like to motion that.
Before we even move with this motion, would the defense even be comfortable proceeding forward with it?
Of course, the defense is open to hearing testimony from everyone.
Thank you, Mr. Gandal. Seeing that the defense would be comfortable with it, do I have a second for this motion?
I'll second that.
Thank you. Is anyone in objection? Just to make sure, I like to make sure with things fair in my board. Okay. Seeing that the motion has passed, I apologize to anyone who thought we were about to finish. The Judicial Board would like to ask for 15 more minutes of the defense. This would include any of the members that I presume Gio is speaking of, any of the members who did not have an opportunity to speak.
Yeah, that's
Wonderful.
correct. So if you want me to be specific, if allows, I can talk to Gabriel Zanapatin, if he's present.
Yeah. Do you hear me?
Yes, I can. Thank you. I just have a few questions for you. It'll be probably very similar to what I asked Mr. Littlejohn and Mr. Palafox. Just can you describe kind of your experience in the commission and under Mr. Pavey?
I mean, I've had no problems at all. I mean, I get along well with everyone, and we haven't had any problems. We communicate with each other, and I don't know, I feel like everything has been handled pretty well, and we've all been pretty responsible and doing our jobs. So, I mean, I think it's been pretty efficient.
Do you think this hearing was kind of a shock to you? What was kind of your initial reaction when hearing about this?
In all honesty, yeah, because I feel like things have been taken care of. You know, we have been in constant communication. Like, we have our group chat where we discuss things and we can voice our opinions. And I forgot if it was Daniel or Derek who said that felt like they could, if they had concerns, they could get them taken care of. And in that way, I feel like it works for me also. Like, I haven't had any problems, but if I did, then that would get taken care of. So I was really shocked to hear about all of this. I kind of feel like it's, not to say a waste of time, but I feel like it's just very inefficient because I feel like it is getting in the way of us getting our job done. But that's just my 2 cents.
I understand. Thank you. And this, as it pertains to the special election, do you recall finding out about the, meeting the signature threshold? Do you recall that?
Yeah, I mean, we were, like I said, we were in constant communication, and things were being told to us, as they were going on. So I mean, I feel like things were taken care of in that way, and there all the steps were done. So I don't. I guess I'm having trouble seeing the problem.
And been like Mr. Pavey, he told you or notified you guys that you guys had a call for a special election. So, when this was told to you, did you guys, have some kind of meeting or talk about when to call this election? Because it's being claimed that there was a special election called. So is this true?
I mean, I don't remember which meeting because I mean, all of them kind of jumble up in my opinion. So I mean, things were done. I mean, are you like asking if there was a specific one for it, or I'm a little confused?
Yeah, no. So when you found out about the requirements being met for the signatures, was there communication between you and the commission about now you guys have to call a special election? Was there communication about that?
Yeah, there was.
Okay. And then was there a follow-up meeting or some kind of correspondence about planning for the special election?
I think it was I believe it to be November. I think it was either November 1st. It was like in the very beginning that we talked about that. It was like November 1st or 2nd.
Okay. That's all I have. Thank you.
Thank you.
If I may, first of all, I want to make sure I got your last name correctly. Is it, could you pronounce your last name for me? I just don't want to pronounce it wrong.
Oh yeah, no worries. I get that all the time. Xanapadin.
Xanapadin? All right. Well,
Yeah.
I'm assuming, are you he, him?
Yes.
Oh, wonderful. Mr. Xanapadin, when we it's looking at the minutes, it's a little weird to the board personally, as Gio was bringing up earlier with other one of your members, that these meetings are kind of not orderly. They appear to be sporadically throughout the quarter and the year. Can you elaborate a bit more on your personal experience on these meetings just being at random times in the year rather than there being a consistent schedule?
Well, we talked about when worked best for everyone, and we had meetings when we deemed fit. I mean, just because you don't have a meeting like every month or every 2 weeks, you're not being productive. I mean, we had them when we felt was best to get stuff done. There's no point in having a meeting if there's nothing like critical to be done at that time. So I mean, we had our meetings, and it was hard getting our schedules aligned. People have different things going on. So I mean, we were able to find the time, and it worked. And in regards to like the minutes, I mean, we talked about things that were important at the time, and I guess if they don't have like exact time steps, I mean, it's hard to keep track of all of that, and we know we got stuff done, so that's what's important.
Go for it, Kat.
As was asked of the other defendants, if you had an issue, did you feel like you would have been able to bring it forward?
Yeah, of course. I would go to the SAG or anyone that's higher up with any concerns. I've never had a problem with them, but if I did, that's what I would do. It would get taken care of. But like I've said, there's been no problems, and I've gone along well with everyone.
Thank you.
If anyone has no more questions for Mr. Xanapadin, we will continue with another defendant, if there are any left. Yeah. All right, wonderful. Thank you, Mr. Xanapadin. We really appreciate your time.
Thank you. You too.
Gio, if you can give us the next person.
Yeah, I'm looking at Max Siddiqui, or sorry if I'm pronouncing that wrong.
You're good. You're good. That's how it's pronounced. Max Siddiqui. I'm a male.
Perfect.
Him pronouns.
Thank you, Mr. Siddiqui. I don't know if anybody else wants to ask. You guys ask questions. Go ahead.
I guess we'll just start with the one that we've been asking everybody, Mr. Siddiqui. Do you at any point feel as though you couldn't speak up to Mr. Pavey about his job or anything?
Absolutely not. No one's scared of anybody, bro. I can say whatever I want to this guy. Like, I'm 27 years old too. Like, I'm definitely not gonna be scared, right? Like, there's no power dynamic. We're a team, and like, I mean, like, he definitely wants us. Like, he definitely encouraged us to like speak up. Like that would be very counterproductive if that wasn't the case. And we're very all about being productive.
Mr. D, you seem more vibrant to speak, so I very very much would like to ask you, do you feel like you, and I want your honest truth on it, obviously. I saw you hitting your vape earlier, so you feel like you're real loose of a person, so I really want you to be honest with us. Do you feel like you're just being thrown into the group when it comes to just being impeached, or do you feel like they're, you know,
Oh yeah, this is clear discrimination. I'm out here doing my job, and then all the like I'm just getting this out of nowhere. Like, yeah, it's clear discrimination. Like, I'm sorry that y'all have to go through this.
It's all good. Mr. Gandil told us that in the preliminaries, and I don't recall if he mentioned it today, but he did tell us that you were not given a notice, that you guys were kind of just all impeached. Is this true? Is that how? Can you walk us through how that occurred?
I don't recall that specifically because I was a member of the Senate and I was kind of aware of there being like a lot of hostility because I was a senator in the past. So like I kind of like, dude, I've had like the busiest schedule. I'm taking only hard classes, so a lot of this stuff is kind of like, if you know, like I don't have the timeline perfectly, but I definitely was shocked. I was shocked that there was a surprise to it. I'm not sure like exactly how it came to me as a surprise, but like it was a surprise, like especially since I'm doing my job, like, you know.
Wonderful. Thank you, Mr. Siddiqui. Does anyone else have any more questions?
Oh, yeah, if I can ask, how do you view your role? What do you view your role to be on the Elections Commission? Like specifically, what is your job supposed to be and take part of?
It's basically to get the election timeline set up right, like have the election website up and running, oversee the election code reform. We were working on that as well, and you know the upcoming election, get that all sorted out. Like this, like you know, like if there are gonna be debates or anything too in the upcoming election, like we gotta get all that worked out, especially with COVID going on. A lot of stuff with COVID going on, we gotta like figure out how to get this all worked out too.
All right, thank you.
I'm sorry. I know you just mentioned like there was some hostility when you were a senator. Why was there hostility? What was going on?
Oh, bro, like there was I know like they're discriminating against me, bro. I wasn't born yesterday. While I was a senator, I was in the Friends of Peter slate, and dude, you saw all the Facebook messages, you saw all those posts on Facebook that everyone's making, like on Zot there are all these like anti-Friends of Peter Zot posts that like all these people who are in the current Senate were commenting discriminatory comments on and all that stuff. Like let's just be honest here.
And then also, you know, as I asked everybody else, you know, when it pertains to that special election, were you notified by Mr. Pavey about, you know, having to call a special election?
Yes.
Okay. And was there a follow-up meeting about it or any like conversation about planning for the special election?
I don't recall. Like I had the busiest quarter, bro. I really had Your Honor, I had the busiest quarter. But like every time like there was a task, I was like on that, like on the website and stuff like that. Like I was on everything, and then I'd be like, all right, like mission complete. And then I'd like jump back on my homework because like my homework like has me sweating.
So would you agree with Mr. Zanapan when he said, even when you guys are not having meetings, you guys are still doing, you know, work?
Oh, absolutely. Like, you know, like I voice my oppositions like to a lot of stuff and stuff like that. Like, yeah, because we have to like we're like, you know, we're brainstorming a lot like with COVID going on and stuff like that. Like we have to get everything figured out, right?
Sounds good. Thank you, Mr. Siddiqui.
Thank you.
Anyone else have any more questions for Mr. Siddiqui? Wonderful. That's everything, Mr. Siddiqui. You are definitely a life of the party in this very tiring hour.
Thank you very much. I appreciate the way all of you have been acting very honestly as well. You especially, you know, I've noticed you've been very honest and straightforward with us, and I really appreciate that, Your Honor. Thank you so much.
Thank you, Ms. Siddiqui. May I ask the clerks how much time we have left?
3 minutes and 37 seconds.
Thank you. Gio, do we have anyone left?
I don't believe we don't. I'm fine with yielding the rest of our time.
Mr. Gandal, is there anyone left?
No, we've interviewed everyone.
Wonderful. Thank you, Mr. Gandal. Thank you, Gio. Seeing that we are done asking all the questions to the defense, we shall move to each side's closing statements. We will be starting with the defense. If you can start us off with your closing statement. You have 10 minutes.
Absolutely, Your Honor. Before we get into the thematic ending of the defense, I wanted to summarize our arguments so they're clear in everyone's mind. First, the board ought to use RONR even if the lowest tier, because Article 1 of the bylaws clearly stipulates that we must do so. Second, when analyzing the evidence today, the proper standard to use is beyond a reasonable doubt. And when everybody goes back to deliberate on this, I want you to ask yourself, is there a question? Is something unclear? In today's case, clearly all of the contentions and charges have unclear elements to them, which means you must find the defendants not guilty. Let's look at financial donations. This seems to be the one that the prosecution hearkened on the most. First, I want to point out this is not a normative election cycle we're talking about. There were many possibilities of alternative venues to submit information at. For instance, you could have submitted it through the Judicial Board. You could have submitted it through the single election commissioner. So for context, there was only one election commissioner at the time. So the Judicial Board oversaw some things, didn't oversee other things. It was indeed a time of great malarkey. And because of that, there was no way to actually adequately substantiate any claims without going through the Joint Committee on Transparency. I do believe, and the defense strongly believes, that if the Senate had done their due diligence and if they'd gone through the Joint Committee of Transparency, they could have determined if there was an actual connection between Mr. Pavey and these donations. But at the end of the day, they didn't. They couldn't. And they had an opportunity to, and they obviously decided not to. Secondly, even if Mr. Pavey did submit these donations, which he didn't, but if he did, it's clear that it doesn't directly apply to him. It's to himself. It's not to others. Again, Mr. Fonseca could have so easily looked at the receipts of others. He could have actually holistically looked at how other slates applied, and then he could have actually made a conclusion that correctly applied to the statute at hand. That wasn't made, nor was that actually attempted. Moreover, even if the court doesn't buy all of this, the primary way of collecting donations was negated by the Knight case. So there's no actual legal criteria to accept this evidence. But overall, this entire process has been convoluted because of the process of the Knight case. Remember that at the time, we were halfway through the election cycle when the elections code got scrapped because of constitutional problems with it. I want you to remember this when you make your final conclusions, because this is going to affect all of the other charges. On being invited to executive cabinet meetings, to demonstrate this charge, the prosecution would have had to actually show reasonable doubt, beyond a reasonable doubt, whether Pavey was able and invited to executive cabinet meetings. The defense doesn't even need to stay long on analyzing this point. Clearly, there was no attempt by the prosecution to even directly state that Mr. Pavey was directly related to all of these meetings. And the testimony by his own witness clearly showed that Mr. Pavey was not needed at any of these meetings. And the only meeting that was even relevant to him was his own impeachment trial, which Ms. Malari herself testified normally they don't notify people of. If we apply the Yan case to this in totality, there is no reason why this is a chargeable offense to begin with, and even if it is not proven beyond a reasonable doubt that it is related to Pavey. Looking at the legislative referenda, this seems to be the one that is focused on the second most. as we've already gone over in our rebuttal very clearly, 3 days, we did it. We weren't able to do it any time earlier because of the professional staff. But because of that, we submitted and applied to the circumstance. Essentially, Mr. Pavy's cut in a catch-22, right? He either does it and he's screwed, or he doesn't do it and he's screwed. And that's because of the lack of elections code. And of course, it's not true that the prior election in 2020 is applicable to now, because because the pandemic was not declared until like the middle of the elections, essentially, and because the Knight case makes this a totally different context and isn't applicable today. So for all of these reasons, Your Honors, you should, on the substantive argumentation itself, find in favor of the defense. But even beyond that, I want to set a narrative here of a politically divided but unanimous Yan court that closed their opinion by recalling Harper Lee's To Kill a Mockingbird. In doing so, the court reiterated the remarks of the defense lawyer for a wrongly convicted black man, which highlighted the reverence for fair treatment of the defendant and importance under the law. In the absence of eyewitnesses, there's always a doubt, sometimes only a shadow of a doubt. The law says reasonable doubt, but I think a defendant's entitled to a shadow of a doubt. There's always the possibility, no matter how improbable, that he's innocent. As we've demonstrated today, not only is applicable through the Yan case, which had an extensive literature review on the empirical effects that our ruling today will have, but based on the obvious criteria that there were almost no eyewitnesses to any of this, and the single witness called by the prosecution testified that it was not relevant. There's no smoking gun. Again, there's no eyewitnesses. The prosecution could have gone to the Joint Committee of Transparency. They could have asked for those verification details. They decided not to. While the defendants have all shown to testify if needed, even staying for this 5-hour trial, not a single one of the senators who were a part of this, including the prosecutor himself, would submit to be questioned on his own intentions. For all of these arguments, we are essentially putting Mr. Pavey into a catch-22. If he immediately had called the elections, he would have been run illegally without an elections code. And if he didn't call them at all, he'd be at odds with the Constitution. So Mr. Pavey did the only thing he could, which is put the elections at a time where the elections code could be reasonably approved, responsibly approved through the administrative process. While that's not relevant now because of the administrative memo on November 30th, what's more important is remembering that Mr. Pavey did everything in his power for the circumstances he was thrown into. And in contrast, the defense does have a smoking gun. It's a smoking gun of discrimination, as illustrated by Malari's testimony. That illustrates there's a double standard. On one hand, there's legislation that's been in the hole for almost a year now, while on the other, there is Senate legislation that's easily being passed through, that is ignoring this process. In short, it is the old maxim, rules for thee, but not for me. Today, we decide if ASUCI is to maintain our democracy founded on the rule of law, or, as Chief Justice Disney feared, decline into the authoritarian grip of majoritarianism. For this reason, it behooves this court, it behooves the students of UCI to find the defendants not guilty. The defense rests.
Thank you, Mr. Gandalf. Seeing that Mr. Gandalf has finished his closing statement, we'll be passing it to Mr. Fonseca. You have 10 minutes to make your closing statement, after which this hearing is over.
Yeah, so the defense alleged there was some sort of smoking gun about the administration policy being applied selectively. He did not say what he was talking about. He just said that it was. I don't know what he's talking about, actually. And it has not been applied selectively. It took a while for some things to be, for the review process to be applied. That was just due to this giant, massive amount of stuff that was going on. There was literally about $2 million trying to be spent that was against UCI policy. And this money wasn't directed to one person or one department. It was directed to several. Like, look at the memos themselves. You can read every single one. So I have no idea what he's applying about that smoking gun. The second part I would like to, the second part, one of the deputies actually said it himself. That was Gabriel Zanapatin. Meetings were called when things were critical. When things were critical, that's when they had meetings. By his own admission and the fact there was no meeting called when the special election was triggered, they did not perceive the special election and our democracy to be critical. They did not call a meeting. There's no evidence they did. They provided nothing. And that right there in itself is 100% dangerous. This is what this is about. Democracy and students' right to direct democracy was violated by the actions of the Elections Commission. Regarding the financial donations, you can go out. I talked to Aaron. I tried to get you guys evidence. He's certified that that's what it is. He's explained to me already that he cannot provide any more because he cannot provide unless you all request it. You have to request these receipts. I did not have access to receipts like the defense alleged. He had access. Aaron has access to it, and he will greatly provide them to you if you all were fully requested. If you request it, you will find that the screenshots I do have are fully valid and are fully authentic. That's no ifs, ands, or buts. That's just the way it's going to be. The second thing I would like to point out, hold on. The second thing I would also like to point out about sorry, let me look at my notes. Also, it's very interesting that the election deputies, by their own admissions, can't even point out when they were or what they were doing when the special election was taking place. The Ryan and the 4 deputies literally stated the same thing, that they didn't know. Well, they knew that there wasn't a special election called, but they couldn't state what they were doing. They basically just said, "Oh, I don't recall," which is very interesting. It's interesting that 5 people will say that all in line at the same time. Second, there's another interesting point. Look, last year, as it always has been, the elections are held from week 7 to week 10 to declare candidacy. And after that, from that point onward, that's when the election process began. And usually it's week 1, spring quarter. The defense alleged that what happened last year with an election being held under the pandemic was irrelevant. Yes, it was, because the pandemic was actually called this week a year ago. Willie Banks himself sent you all an email about that and basically sent you all an email about that on Thursday, I believe. I think that was either Tuesday or Thursday, literally saying it has been a year since the pandemic, since everything went offline. So the election process was in after finals week of winter quarter. That is when the election was held. And they basically said that the elections commissioner didn't know how to do an election in the pandemic, and they didn't know how to do it or what to do, and instead it has never been done. Do the math yourselves. It doesn't make sense. The pandemic did happen under COVID. It did in fact happen. The videos are still on our the videos are still on our Facebook ASUCI live streams about people doing the debates via Zoom and everything and all that stuff that came and tells. The election did happen. So to say they didn't know what to do in the pandemic, it's just, and again, they lied about it, saying that there's ever been an election in a pandemic. That right there, Ryan has demonstrated to us several times he cannot be trusted. The deputies did not perceive their actions did not perceive calling a special election to be critical. That right there shows that they don't take their job seriously. That's what it's about. They do not respect direct democracy. Sorry if I ramble. I do have a tendency to ramble. Hold on, sorry. There's a third thing here. So Ryan Pavey, deputies. So they have clearly demonstrated that they do not take their job seriously, and they didn't perceive a special election being called as a critical thing to do. They did not call a meeting. The other thing, look, at the end of the day, democracy is sacred. Democracy is something we should enforce. Democracy is something that must be held to the highest value and the highest standard. If you for a second believe that these people are not trustworthy they cannot be trusted with the elections process, and by the way, the election process, their power is literally, they have the power to literally disqualify candidates. That is within their power. If you do not believe that they should have this power of theirs, and you probably just, again, you don't believe that they should be impeached, I ask you as a judicial board to do something. Because as of right now, I'm telling you, as Senate President, I get a lot of emails. People think asking me about the elections. They know I'm the Senate President. They have questions. Oh, how is it like to be senator? How is it like to run and all that? They know what happened with the Elections Commission and the deputies. They do not trust them, and they are terrified out of their minds. They are terrified that they will be DQ'd because they don't trust these people. So I advise you, even if you do rule that these people should not be impeached or they should not be removed, even though I do believe, and I did make the argument they should be removed, do something about it and join yourself with the Elections Commission. Last year's Senate, last year's Judicial Board, do it, please do it. Or else, if you do not do it and you let the elections to run the elections purely, this election will be an overall disaster. These people, these deputies and commissioners have continuously lied, and do not care about democracy. And they have stated out their own statements. They have said several things, and our democracy is in danger. That's really what it comes down to it. If they were not the ones in charge of the deputy, if it wasn't them, these people who were in charge of our democracy, honestly, it is very likely impeachment would have never happened. The only reason we brought up impeachment is because out of all people who should know or respect our democracy process, out of anyone in this government who should know our elections and democracy processes, it is them. They should be the most honorable. They need to know the most rules, and they need to have the most respect for it. We decided to impeach them because they did break their constitution. They did violate the Constitution several times, and they cannot be trusted. And I have I have shown you evidence. I have shown that they did not call a special election. I have shown they themselves said it. They did not perceive it to be critical, and so on and so forth. Hold on, how much time do I have left?
2 minutes and 7 seconds.
2 minutes and 7 seconds. Oh, there's literally one thing that there's one thing I keep forgetting to say. Deputies, elections, commission. Oh, they claim they don't know how to donate, how the Brian Pavey himself claimed he doesn't know how the donation processes work or how they function. He's the elections commissioner. If there's one person who would know, it should be him. How can he say he doesn't know? And how can he say he doesn't know how his name came up there? It doesn't make sense if you think about it. He should know more than anyone else. Aaron, oh my God. And again, the very last thing I'll leave you all, this idea of the smoking gun, this idea of discrimination, it's baseless. It really is. Their smoking gun, I still don't even know what it is, to be honest. They just say rules were applied selectively. And again, that's not true. Rules were applied to everyone. Last year's Senate just refused to hear it. And I guess, look, as a Senate, we will respect any decision you guys come up with. That is just the way this should be done. We wanted this hearing. I could have made the argument in the pre-hearing that we should not have a hearing. However, I knew that the best way to do things, the best way to restore honor and respect and trust to our democracy and to this government was to go through this 4 or 5 hour process and have this hearing to determine whether or not they're guilty or not. I literally, look, all I'm saying is, please act, do all of your jobs, and I want truth, respect, and honor to be restored to our government. Last year, we lost a lot of credibility. It is now the time when we go back and restore our credibility. That is what I've done in the Senate's entire year as the new 7 justices. I hope you will do it too.
Thank you, Mr. Fonseca. That is the end of everything that we have for this formal hearing. We appreciate everybody being here. As we stated beforehand, we will be deliberating on this tomorrow, and we will be coming up with a decision over the course of this weekend. At the absolute latest, we will be posting our opinion on Tuesday, but we are taking into consideration that the Senate does require an answer a bit sooner due to elections, but that is not a promise that we will actually be making our decision by then. Does anyone has any last minute questions? Now would be the time.
Oh, sorry, this is more of a Senate procedural thing. We have elections referendum coming out on Tuesday and Thursday where we have to vote in order to put them on the ballots. Removing the elections commission, if they are removed, or specifically commissioner, puts an injunction on all our legislation, basically mean these referendums cannot be put on the ballot if you guys decide before, if you guys release the ruling before our meeting on Thursday. So I make your decision, and I will request that you release it on a Friday, or else like the esports referendum that's on our website, that's on the website right now. If you guys release your referendum before Tuesday or on Tuesday, we basically cannot put it on the ballot, and it just basically dies. And the esports has been pushing for that for like the beginning of the fall quarter. So like they will, it's literally will just be throwing out their entire work. That is, I guess, like my request. I really don't want that to happen to them, the esports arena, and the other referendum that's not coming to us soon.
Understood. Thank you, Ivan. We'll take all these things into consideration. Anyone else have any more last minute things that they'd like to present? Not even present, just talk about with us. No? Okay. We really appreciate everybody being patient with the board throughout this time. We know it's been an incredibly long and stressful process for everybody. We really appreciate everyone's patience. We do hope that everybody respects and understands our opinion. We do not wish any negativity towards anyone or anything. We are a fresh board. We do not personally know anybody in the Senate. We know only of names and anything. We were specifically chosen because we don't have any real connections to anybody. So when we make our decision, just please know that our decision is based off what we were presented, our own intellect and our own arguments. We will not be referring to any outside sources. We will not be referring to anybody outside of our own 7 members, including myself. Everything will be up to us and us alone, and all of our decisions are made on our own behalf. If you have any problems, any questions, you have any comments or concerns about how any of this was made, please feel free to email us, or you can contact one of these 2 representatives and they can probably push that forward to us. And that is everything I have. Does anyone have any last minute things they'd like to say before I end this meeting for all?
Well, I guess just to be, for the sake of transparency, Andres, I know you emailed me about financial stuff for Judicial Board. Our finance chair is getting that, and that's not relevant to anything.
Yeah, that's just so personal business that you're bringing up.
Yeah, that's not relevant to anything. I just wanted to be transparent about that.
Thank you for the update, Ivan. Appreciate it. Mr. Pavey, I see that you came on.
I just have one small update. On behalf of the Elections Commission, I just want to say that if we are ruled to be innocent, the elections will be carried out as they always are, and it'll be fair. No candidates will have to worry about any sort of discrimination. It'll go smoothly.
Thank you, Mr. Pavey. That was quite concerning, though. If you're not found innocent, what happens on the other end of it then? Thank you, Mr. Pavey, for your comment.
I would still be fair in that scenario too, of course.
I sure hope so, Mr. Pavey. You really said that in a really ominous way.
No, I didn't mean anything ominous. I just, no matter what, we'd be fair. But if we're chosen, don't think like we're chosen to be innocent, like we're not going to do our job well or anything like that.
Wonderful. Thank you, Mr. Pavey. I appreciate it. I'll give a couple of moments or seconds for anybody to make any final comments to us or anything, and then I'll be ending this meeting. It will just be closed. There won't be any waiting rooms or anywhere where you can chat. It will just end. All live streams everywhere will end. I don't know where they are, but they will just be ended.
I guess I just want to say bye and thank you, justices, for like staying for 4 or 5 hours. I have been in 4 different 10-hour meetings. They're freaking growing. It's intense. Thank you guys for staying this entire long. Andres, I saw your screen. You're applying to some grad school. Hope it goes well. I'm applying for grad school right now too.
Wonderful. Well, good luck to you, Ivan.
What are you applying for, actually?
Political science doctorate.
Oh, nice. I'm applying for a master's of public administration.
That's super rad. Yeah, I was actually looking at actually doing a master's in that as well. So if I do get denied from that, that's definitely what I do plan on going forward with.
Yeah, it's really cool. All right. Bye. See you, everyone.
Have a good one, Ivan. We really appreciate you. Thank you.
Yeah.
I see we still have a few left here.
I just want to say thank you for you guys' time. I know it's long, I enjoyed sitting through this. I learned a lot. Thank you guys.
Very good. I hope you're not cold out there in your backyard.
Well, I'm not. I got my gloves off, just relaxing.
Cool.
Quietest
All
place
right.
in my house.
All right. Well, thank you, Mr. Littlejohn. We really appreciate your time.
All right. You guys have a good one.
Have a good one. Yeah, you too. 1, 2, 3, 4, 5, 6. There are 2 extra stragglers here. Ah, yes, Mr. Sadiq and someone.
That's it.
That's it. All right. Well, thank you for everybody who watched this. We really appreciate everybody who came to watch the public formal hearing. As we stated earlier, our opinion will be released later. Thank you all for coming, and we are